Hey, jerks, what's up? Oh my God, I'm so amped tonight. I'm feeling a little more rested. You may have noticed the last couple months, especially. I've been working too hard, dog walking, and my schedule finally today got easier. I don't have that 9 p.m. walk. I could stream all night tonight. So I'm feeling good. I am feeling like ready for spring, ready for the retrial part 2 tomorrow. The jury impanelment that's probably going to last for weeks, so we're not going to have anything really to talk about probably for 2 weeks, but it's going to begin tomorrow. It's going to start, and I'm excited tonight that we have attorney Mark Bederow back on the show, and it's a little bit different tonight. It's just one thing different. We're not doing the crazy super chats where we turned them off tonight. We could actually have them up on another night, but this is kind of like an experiment too, and just due to the fact even me, it just stressed me out getting all those super chats. It was just too many. We couldn't get them up. People got mad at me. And it became a thing too, where people wanted to get their question answered, which I think super chats is more really about rewarding the YouTuber, the creator. So you can do that tonight. We'll turn them on at the end. But for now, when we have attorney Mark Bederow tonight, we're just going to chill. We're going to have a fun show. And there's so much that has happened today. We got jury selection tomorrow. We got motions that we're going to talk about with Aiden Kearney, maybe even tonight, that just have been filed that should hit the docket maybe tomorrow. We're going to talk about other things that have happened today, the filings, the rulings, excuse me, from Judge Bev Canone, Michael Easter, the third party culprit, the ARCA stuff. There's so much to talk about. So let's bring them up. This is exciting. Attorney Mark Bederow on the evening before the Karen Reed retrial. Welcome back to the show, Attorney Bederow. Mark.
How are you?
Good. I'm a little pumped up tonight. Can you tell?
A little bit.
Feeling
okay.
like relaxed and like just ready to go. Like I've been tired. I have been. But now I feel like okay, this is easier schedule, and I get to watch all this, and it's just going to be amazing to see what happens here. So we've been waiting, the anticipation. It starts tomorrow. I'm ready. This is like the playoffs in a way, right?
Yeah, I mean that's the big retrial, but it'll be pretty uninteresting perhaps for a week or two or more. But onward and upward, and it starts. So you have to start somewhere. So they're off tomorrow.
The chat's already noticed your sweatshirt. Go Celtics. That's always a question. What sweatshirt you gonna wear on the show? Celtics is the main one.
It's the Celtics are still in rotation. They're champs. They're gearing up for another run. So they stay in the rotation a lot longer than perhaps the Patriots and Bruins, right?
Yes, and the playoffs must be started, right? March is usually
a couple weeks.
Couple weeks. Okay.
Yeah, sometime in mid-April.
April. Yeah, after March Madness is over.
Yeah, mid-April.
Mid-April. Cool. So here we go. Mid-April, couple weeks. Just kind of like Karen Reed, actually, because I mean we're starting April 1st, but it's gonna be jury selection. Probably what, 2 weeks? I bet it's at least 2 weeks. What do you think?
I don't know. I mean, once again, the way they do things out there are different. My understanding is that they go to sidebar and do one at a time, which takes a long time and really neuters the lawyers from doing much. Most places, the traditional way is to impanel a veneer that could be fill the jury box, and you could even fill up the rows of the courtroom and address several at a time and have a conversation. The lawyers try to engage with jurors, make a connection, start addressing issues in the case. Again, brainwash and get rid of the wackos is the key to jury selection. But in this courtroom, in this state, there's none of that. So it's the process, I think, by definition, will take longer when you're doing literally one juror at a time. And there are going to be so many that are going to get screened out because they're going to have too strong opinions about too many things. I really don't know how they're going to do this in an effective and productive way. So I would expect it to take a very long time.
On the last trial, been a lot of questions about how they selected jurors and how this new attorney became an alternate juror, for instance. Doesn't seem to be any transparency, but how the numbers are selected and people get to see, they don't get to see it. Do you think that might change this time? Is there anything that the defense can do to bring more transparency and trust to the jury selection process, let's say?
I don't know that there's anything that the defense can do to bring any more transparency or public trust in the trial in any component, given what you've seen over the past several weeks. I mean, I think they're well positioned to win, but they don't seem to be getting many rulings. And, you know, there's this thing called the Sixth Amendment, which is pretty important, which talks about the right to present a defense. And a lot of their attempted ability to present a defense over the past few weeks has really been sliced and diced. And so I don't know why there would be any more transparency as it relates to jurors. You've seen the buffer zone double in size. You've seen an order today which actually makes it verboten for anyone to even describe a physical appearance of a juror in terms of age, color, clothes. I mean, so if anything, you're seeing much less public access, much less transparency, which is very unfortunate, particularly when you're talking about a case that is so high profile and so much a matter of public interest. And you would want more light on a case like that, not less, but this appears to be trending in the other direction.
Absolutely. And that's the thing, too. We can all think about these things we'd like to see in this trial to make it fairer. But the defense never wins. It's so rigged against them. And the public, too, like for the transparency part of it. It just gets worse and worse and worse.
Well, normally you would want the court to err on the side, again, on a defendant's constitutional right to present a defense. You know, if there's literally no good faith basis or no evidence to support some of the things that they want to do, then a court certainly has the discretion and ability to preclude certain things. But I know when we get into some of this today, to literally preclude, you know, a third party culprit based on what's been presented, and to severely limit, perhaps, depending on how it shakes out, a third party culprit defense at all, to deprive an expert on crime scene things, to not allow the jury to get a full understanding of where the ARCA people come from, in particular, given what the prosecution is going to allege, that there's some kind of hired gun who's biased in favor of the defense, which is, I mean, that's just patently absurd based on the timeline and the allegations. These are all things that you would expect a judge to err on the side of, I'm going to allow the defense to do this for those kinds of rulings, but not here.
Talk about those motions, because the rulings on them, the biggest one, I think, so is the Michael Easter one, that she's not allowing him to testify on policies and procedures and his opinion on the bad investigation, basically. You know, I'm not quoting it directly, but it's pretty much that. And she's basically saying like that if the average layperson could see that they screwed up the investigation, you don't need an expert. Like, that seems really weak, like very weak, like considering that I don't think the average person knows how the Mass State Police investigate things. It just seems, that one seems really biased to me. Like, out of all of them today, that one was just so outrageous to me.
So the standard for, you know, that kind of expert, or any kind of expert really, is for, if the subject matter is, at least in New York, the buzzword is beyond the ken of a reasonable juror, which is just legal mumbo jumbo for, you wouldn't expect a layperson to fully understand. And that's really why expert testimony would come in for any subject. So what's interesting in this case is the key or a key component of it, what they call in Massachusetts a Bowden defense, which is really just the cops did a terrible job, and because of their incompetence, because of their deliberate corruption, whatever it is, that reasonable doubt was created by that. So now you get to the issue of, is the defense allowed to present an expert to explain to the jury something that may be beyond their general knowledge, to really drive that home, that the crime scene securing, the nature of the investigation, that what they did is just not professional. So, they have an FBI agent who presumably meets the qualifications for this. And what was interesting about the decision was, number one, there's no Massachusetts case that, the judge said allows this or has held that this is okay in this situation. And that's not really a reason to just out of hand deny it. There's always a first time. There is an obvious Bowden defense here. There is an obvious atrocious work by the Canton police, the state police, arguably anyone in law enforcement who was involved in this. It would seem to me that an expert would really explain what that is. And the most troubling part of the decision was the judge's explanation that, well, what's the difference? There'll be vigorous cross-examination, and the jury, lay persons or not, will be smart enough to know that you can cross-examine on what a good crime scene is or isn't, and that'll be enough. And that's great unless and until you get cops who aren't going to give you that, or they're going to argue. And now the defense is in a position where they're trying to extract information and appears to be arguing or badgering witnesses when they need not do that. There's an expert that can explain it. They just may not get people to give it up. You may get police officers who say, well, I'm not really qualified to make that judgment, which would be ironic because you need an expert who can make that judgment. And then you're left with the fact that we're being told that, if laypersons can understand how to do proper police work, but in this case, the defense is alleging that the cops don't. I mean, you're giving the jurors more credit as laypersons than the actual Canton police and state police who are supposed to do something. So what it does is it puts the defense in a position now to have to really go after these cops, try to extract this information, and then argue in summation why they didn't do it, and have to listen to the DA with the last word. The DA is going to get the last word here, say why it's no big deal. And if the defense had an expert to say, no, here's why you do this, here's why it's important to do that, that would carry a lot more weight. So again, given the Sixth Amendment right to present a defense with all of this that's going on in this case, recognizing that this is completely relevant to the defense, I don't think a lay person understands exactly what it means to secure a crime scene. Some may. If you ask a lay person, why does chain of custody matter on bloody clothes? I'm not sure they know that. They may know it from watching TV shows, but that's not what we're talking about here. They may not know the significance of allowing, someone who they classify as a witness, but not a possible suspect, entering a house, talking to someone, not being interviewed alone. Those are things that certainly they can argue, but I think it's a little misguided for the judge to just assume that any layperson would understand that. And the judge's advice to the lawyers is just give it your best shot on cross-examination. And you can't underestimate this point. They may have to really go after the cops to get it. And they're going to look argumentative. They're going to look difficult. And, that's not necessarily fair either. So that one is such a ground ball ruling to just say, I'm going to allow this. You give the instruction on what an expert is allowed to do and not do. They're just allowed to explain procedure. They're not allowed to give an opinion on what it means or to draw conclusions. But if they allowed this expert to give his opinion, then the defense in summation would just take that opinion and run with it, plug it into the facts in this case, and they would be off and running. That decision makes no sense. I don't think it's it's not going to change the result in the case, but it makes it a hell of a lot more difficult for the defense to establish points that really the jury ought to be able to be told by someone who's qualified to say, here's how you do it.
Michael Easter, his testimony, could it be allowed later? Because Andrea Burkhardt made a post I saw just like in the last hour or so about this, and she basically said the defense should request it after the cross-examination of those cops. So if they get something good that's due from those cops, then they should try to resubmit Michael Easter to speak. Is that possible, or is that just like a Hail Mary? Like, what is that?
Yeah, that's a Hail Mary. And I mean, I get it. And, Andrea's always thinking outside the box and is as good an appellate attorney as it gets. In the real world of trial practice, is that a real thing? I don't know. Well, I mean, the other thing is this: if you get what you want from the cops on cross, does that not kind of undermine the need for an expert, actually? So, I mean, look, if the cops are admitting, yeah, this is not how we're trained to do it, this is not ideal, we should have done this instead of that, I think actually that would undercut against allowing an expert, because the jury would have what you want, and they still may get it. I mean, any police officer who testifies at this trial who says it was right to abandon a crime scene at 6 a.m. and just let it go because there was, some snow on the ground, I mean, that's just stupid. That's not the case, especially here where the integrity of the crime scene is so important as it relates to the taillight pieces that were allegedly found there naturally, 12 hours or give or take after the cops first arrived. If they had secured that crime scene, there'd be no issue here, right? I mean, that taillight would be there. But in this case, it's a huge issue. And again, we've talked about this before. It goes to the chain of custody. It goes to the way whether they wanted to look at other suspects before they just tunnel vision their way to Karen on the way down to Dighton that day. It goes to the failure to document, photograph, test the car right away. I mean, this could go on and on. I think it's a regrettable ruling, although it's not one that's going to harm the defense. It just makes them do things in a way that they really shouldn't have to do.
Should not. That I was actually going to ask from Christina. She says, can the defense make an interlocutory appeal to Michael Easter? And I would add to it, should they even bother wasting their time on it?
No, I mean, it's a discretionary ruling by the judge. You're not appealing unless there was an abuse of discretion. And, when judges get discretion, this is where a lot of these decisions can really be harmful if it's just someone who doesn't appear to like your arguments. Discretionary rulings don't get reversed unless there is an abuse of discretion. And this, I mean, could these be issues if they're cumulatively considered, if there was a conviction? Maybe, but nobody is stopping the trial on the eve of jury selection to do this. And Stephanie's right. I mean, that's the point. The investigation is terrible. What I just said about the crime scene not being preserved and how the taillight gets there, they can do that very easily. Not looking at other suspects and just rushing down to Dighton to take the car before you even saw it, without photographing it, without doing this, without doing that, without chain of custody. These guys are professionals. They'll do it. They'll explain how it's reasonable doubt, but they have to do it in a way that's just really shouldn't be necessary.
That's a theme here with LTL Media. What he's saying, keep hammering home reasonable doubt. Is that one of your things that you should think the defense should be doing over and over and over again, Mark?
Well, yeah. I mean, that's the goal of the exercise. And I'm sure we've talked about this in the past. In the summation, there are so many facts which standing alone would suggest reasonable doubt. You point that out, and then you add the next fact and say, where are we now with the reasonable doubt? And just keep adding fact and fact, keep putting every pebble on the scale. And at some point, it just becomes clear. So, yeah, I mean, everything is reasonable doubt. Even this whole thing with this whole third party culprit, to me, that's always been semantics more than anything. I mean, if your position is a car did not cause death, that means she didn't do it. Well, by definition, that means somebody else did. And if the car didn't cause that kind of impact and would not have led to the taillight to end up allegedly shattered in 47 pieces or whatever it is, the way that the prosecution alleges, well, that means it had to get there some other way. Well, that means somebody else put it there. And if somebody else put it there, they're trying to cover up something. And you can see how this all ties together. And at the end of the day, all they've got to do is get reasonable doubt. So yes, that should be pounded again and again. And, you know, when you think you're done, you should go back and pound it one more time. And when you think you've pounded it enough, you should go back and hit them 3 more times. I mean, it's all it is. This is not an exercise in proving what happened, which is also part of the risk of a third party culprit. The jury kind of assigns a burden that they're not supposed to if they start focusing on that. It's just reasonable doubt. And if they walk out saying, we don't know what happened, we're not sure whether she did it or not, that she's going home, period.
Third party culprit. I want to talk about that ruling, but the filing for it too was interesting because it did bring up the JFK microdot stuff. You know what I'm talking about, the tussling or the pointing, the pointing, you know, that was going on in that bar that they highlighted. Those 2 creators, YouTube, microdots and JFK, they focused on that heavily. Do you think that's going to come up? I think obviously it's going to come up in the trial. I mean, what even with the JFK, like they think that a lot of us think that Higgins called into JFK's show. Do you think that will come up in the trial at all? Do you think they'll ask him about that? The defense would.
Well, let's start with the waterfall video. All right. You know, at this point, I don't know who's doing what or how they're doing it. I'm not a part of that. What I can say is, I mean, if I was cross-examining Higgins in particularly, I would have a field day, Zapruder film style, frame by frame, second by second, on what the hell is going on in the waterfall vis-a-vis him humping around with Brian Albert, him looking at his phone, him texting Karen, him texting John, him looking at John, him pointing, John kind of pointing back, and him leaving and texting later, are you coming over? Are you coming over? I mean, I think that is significant. I mean, certainly if your theory is that Higgins is a viable candidate for doing this, that's big for sure. I mean, I guess to some extent, but maybe a lesser extent, Brian Albert too. As far as Colin Albert, I don't even know if he's a witness in the case at this point. I mean, I don't know why the prosecution is going to call him. And at this point, since the defense has been so neutered about Colin, you know, how much of this stuff about him not appearing on any police reports and whatnot are you going to get into, lest you be accused of opening other doors like in the first trial? So, you know, the irony is the defense has always alleged, and many in the public have always alleged, that Colin was left out, was this, and this was all just a way to kind of whitewash him from anything. And I don't know what he did or he didn't do, and it doesn't matter what I think anyway. But with this ruling, that only feeds the monster of the people who believe that. I mean, he's literally been whitewashed from this based upon a judge's, what I would think is bizarre conclusion that the evidence established that he wasn't in the house based upon some dubious, to be kind, screenshots between 2 witnesses who, you know, why they don't have original phone records and things like that. And they were denied access to all of these phone records. They were denied access to the third party culprit phone records. And, you know, this has to be profoundly disappointing. It certainly would be for someone like me, because of this whole, in Massachusetts, it's just so damn hard to get any evidence from a third party. And it requires this, you know, this ceremonial motion practice and hearing and this and that. And, you know, in New York, as a lawyer, you just fill out an affirmation, not an affidavit, by the way. It's an affirmation by a lawyer. You would go to a judge ex parte and explain why these records are relevant to our defense. And if a judge signs that so ordered subpoena, then the subpoena goes to Verizon or whoever. And you know what happens? A couple of weeks later, those records show up in the court, and the court either A, looks at them to make sure they are what I said they should be, or B, calls you up and throws it in your face and says, get out of here. But in Massachusetts, it's a whole production, and they get denied more often than they get granted. And it's truly bizarre, in particular, when they're making a good faith allegation for who the third party culprits might be. So as far as the Higgins or not Higgins video, you know, the Kevin from South Boston or whatever, I don't know. You know, you're never going to prove it. Let's put it that way. Okay. Does it sound like him? Sure it does. Can you prove it's him? No. So you ask him about it, you confront him, and he says no. Where are you going? You're not, I mean, it's over. You're not calling other witnesses to prove it is. So ultimately, what do you get? Now, if he admits it, you know, you could argue it's consciousness of guilt, you know, which you've heard a lot about as it relates to Karen in the last couple of weeks. But I don't know. That's kind of a feel on how it's going with Higgins. I wouldn't commit to that kind of stuff without getting a feel for what's happening.
That makes sense, because it would be hard. I mean, I keep thinking, like, if you could prove that was him, it shows consciousness of guilt. That's exactly what I was thinking of. But it's like, where do you go? Like, when he says, no, it wasn't me. Like, it's kind of, yeah, you have nothing really. So,
I mean, look, you could completely argue that if this guy who is a key witness in a case is listening to people like you and other guys talking about it, and then calling in, lying about his identity, challenging some of the factual assertions, he gets called out and then puts on, you know, a towny accent, denies it's him. Yeah, you could totally argue that's consciousness of guilt. The problem you have is you have no real way to prove it's him. It sounds like him, but that doesn't necessarily mean it is him. You can't prove that.
Yeah, it could be a good impersonator. I mean, I think it's him. It sounds so much like him, but it really could be an impersonation.
I don't know if, listen, when you know, obviously credibility matters as a lawyer, and you have to make a judgment call. Am I going down that rabbit hole, or do I look silly with this? I mean, I've got this guy, right? All that waterfall stuff. You've got him
right
torching his phone. You've got him making sure no one ever finds it. You've got him feeling ghosted by Karen. You've got some interesting stuff with him. Doesn't prove directly that he did anything, but you've got some interesting things with him. I don't know that I want to dilute that with some kind of nonsense about, you know, him being, you know, Kevin from South Boston. So again, you don't make a decision in advance, but my gut would say probably not.
That seems like that. It just doesn't seem like it's, especially when you have all that other stuff. Like,
that's right.
Like the pointing, like the text messages, like the ghosting. That's the really good stuff for him.
Yeah, the tossing the phone on the military base into multiple pieces, coming up with this kind of silly explanation for why you did it, right at the same time as the preservation order is going out. You know, I mean, moving cars at the police station while you're on the phone. There was no video of that. I mean, you could go on with this stuff. If you're going to argue seriously that someone else was involved in committing the crime, if that's the way they're going, then he's probably the strongest candidate based upon the evidence. But on the other hand, call it third-party culprit or not, they don't need to do that. I mean, you can say there is doubt that she did it, and I don't know who the hell did it or what the hell happened, but it wasn't the car. So, and I don't know why. I mean, this is what I would say. I don't know why these people are acting so guilty after the fact, talking about they're digging up the Asian guy's house and tell him he didn't go in this, and butt dialing. I mean, again, Higgins and Albert have what I believe is probably the only example of a butt dialing conversation, a back-to-back butt dialing conversation in cell phone history, probably. You could go on and on with this stuff. So I don't know that I'm even suggesting what they did as much as I don't know what the hell they're doing. They're acting weird. Somebody did something, but it ain't her. And we know that because XYZ. And, you have to ask yourself, why are they acting in such a suspicious and guilty way at a weird time of day when nobody should know anything? That's reasonable doubt. So I don't know that I'm coming up with theories about, what Brian Albert did in the basement or not. But, that's for them to decide.
Really. Buddy, someone said they should ask him if he knows a guy, Kevin from South Boston. Let's see what he says. I thought that was cute.
Well, the problem you run the risk is this: it's going to get sustained. He's going to object. It's going to be sustained, and the jury. Look, in theory, they're going to be voir dired at the bench, of course, so you'll never know what's going on. Right. Don't be surprised if your name and some other people's names come up. I mean, clearly they're going to ask people, do they watch this stuff? Okay. Do they, this can be influential for a lot of reasons. I mean, obviously, I think people who watch this are inclined to think that this is, a railroad job. I think that's the case in probably 95% of this stuff. The 16 people who watched the guy in the attic and the other stuff, that's different. But the bottom line is the jurors on the case presumably will not know what Kevin from South Boston means. They shouldn't anyway. So it'll be sustained. And to me, it's more funny for, people who talk about this than people in court handling a very serious case.
Freddie Culper, we've been talking about that too. Do you think it seems like that is kind of a win for the defense, because they get to say, if they want to go that way, they got two names. They got both the Bryans. I mean, they didn't get Colin, but they got both the Bryans. And I think they got more on them too. So I think that is kind of a win for them, right?
It is, but to me, this has always been semantics. So suppose third-party culprit is denied. They're allowed to argue on the waterfall video that you guys are, jawing around with John O'Keefe and you wanted him over there. I mean, what can't they do is accuse them by name of, theorizing that they killed him. But again, you're allowed to present alternative scenarios as part of reasonable doubt. I mean, it's a fine line with all of this, but the defense here primarily is John O'Keefe was not killed by a car. Okay. And because of that, all of the evidence that the cops claim they found on the scene and all the shitty police work that they did, it's all compromised. It appears to be planted evidence. It appears to be all these other things they did wrong, but that all goes to reasonable doubt. But that also, any juror is going to understand what that means. If she didn't do it, well, there's only so many other people, presumably, that would have an opportunity and the ability to do it. And so it really is semantics. But I'm not sure there is any point in naming names and going down that rabbit hole. You could say it could be this. Yeah. It could have been that. It might be this. But there's no proof beyond a reasonable doubt that it's what the ARCA guy said it wasn't. And you're supposed to take Michael Proctor's word for this. And you're supposed, there are so many ways to wrap this ultimately around reasonable doubt. And you can't lose sight of that. And that is far and away the biggest thing, is marshaling the available evidence and drilling home the point that all we're doing here is providing you a reason to doubt that she's guilty. And all reasonable means is that, it's a sane person recognizing that it's plausible it could have been something else. That's all it means. That's a very low quantum of evidence. Evidence isn't even the right word, because the defense doesn't have to prove anything. You're attacking the prosecution's burden, but it's not that much to have to kind of screw up what the prosecution's trying to do.
It still can't be disclosed by the defense. That's a part of a ruling too now, that they were hired by the feds. That's just, I can't believe that we're still dealing with that too. That was just decided as well, right?
Yeah, I mean, the ARCA thing that's been going on the past few weeks is, you see the way the prosecution is handling this, and it feels like Shakespeare, what they're doing. Methinks thou doth protest too much, methinks, or whatever the exact expression is. Their obsession with trying to dirty up ARCA, preclude them, claim that they're in the tank for the defense, claim that the feds and the defense are in bed together to do this. This is such abject nonsense. And the timeline establishes that. The defense will get the timeline out there, and then the pressure will be on Brennan in terms of whether he wants to clown himself by seriously suggesting with a straight face that these are bought witnesses. I mean, the timeline is so straightforward and so simple. They get hired by the Justice Department. They don't even know what for, really. They don't know who the parties are, and they're given this project to do, okay? And they do it. They don't know who's involved in whatever. And based on all the available evidence that they have, that they're given, they reach in their mind, a solid opinion, okay? And that opinion is twofold bad for the DA. Based upon the factual premise we're given, the car doesn't appear in the right condition for that kind of impact, and nor does John O'Keefe. So that's bad for the DA. That's terrible. That opinion is held in the Justice Department for a couple of months. And, then you have this extraordinary thing. Everybody knows TUI requests and TUI disclosures, which are very rare. And the feds dump it on both parties. And for the first time, the defense becomes aware of this. And of course, when they become aware of this, that is the quintessential exculpatory opinion. I mean, the fact that this tends to show that there was no car accident causing John O'Keefe's injuries. Okay, it is obvious at that point that the defense is going to do anything and everything in their power to get those witnesses to testify for the defense, because they are as exculpatory gets. They have to go through the Justice Department to get them to testify. They do. They go through that whole procedure. After the trial is over, ARCA sends them a bill for $20,000, which, again, anyone who does this for a living understands what this means, including Hank Brennan, by the way. Let's be clear. I mean, let's at least be intellectually honest about what we're talking about here. Those guys, that firm, given how credible they are, how high level they are, would have probably been paid anywhere in the vicinity of $250,000 to $1 million for their work, okay? And that would have been paid by the United States Justice Department. Now, but they are told that they're going to be defense witnesses in a state court case. So they travel from, like Philadelphia, Pittsburgh, wherever. They have to fly in to Boston. They have to stay in hotels. They need to eat food. They need to whatever. So they send a bill after the trial. There's no evidence of any discussion about getting paid before they testified. This is after. They send a bill for $20-something thousand, which I hate to break this to people, that's peanuts. That's nothing in how this works. That is almost symbolic expense.
Drink.
Now, so to allege at trial that after it comes out, when these guys say, we got our opinion in February, we didn't even know who the defense was or who the prosecution was. We were contacted by the Justice Department, who told us that in this criminal case that the defense wants to meet us and testify, and we did. And you stop right there. They didn't know who they were at the time they rendered the opinion. So by definition, the opinion is not biased. A third grader can understand that, okay? Then they get this, pissant sum of money after trial, and we're supposed to believe that this prosecutor is going to cross-examine them after all this and say, yeah, but you got $20,000 and this somehow makes them biased for what they already concluded before. This is absolutely ridiculous. I still can't believe that he's going to do this. I still think he's not going to do this. But they have a problem with the ARCA people, and that's why you see all this effort to do anything they can to discredit them. And then they're going to try to discredit them about, well, you didn't review all these materials. And, the only interesting question is going to be, is the defense going to be able to argue and introduce evidence? And I'm not sure they can do this. That one of the reasons why the ARCA guys didn't have all the evidence is because Lally didn't disclose it and they didn't have it. And then when they were told at trial, if you had this, would that change your opinion? And they said no. And the reason it wouldn't change their opinion is because they're talking physics, kinetics, and all this other stuff that I don't understand. Perhaps you don't. But so you see them hyper-focused on trying to do anything and everything to dirty up these witnesses. That's because they know that if these witnesses are deemed credible, that the case is essentially over, which gets to the point 20 minutes later, where you mentioned they can't say the feds. That's true, and that's regrettable. That could theoretically open the door, I get it, to the whole federal investigation. And then the DA would say if that all came out, then they should know that there were no charges. To be honest with you, if I was the defense, I would make that trade. Okay, I don't really care that the feds didn't charge anyone because there wasn't enough evidence. The point is that they didn't do anything to Karen Reed, and that their experts don't think that she did it either, based on the science. But since they're not going to be allowed to do any of this, they're just going to have to really drive home that the defense had nothing at all, and they really need to get this out the best way they can, that it had nothing to do with any, us, any civil defense, any insurance company, anything.
Yeah. We got a question on that from NDF. I'm wondering, can they specifically just ask ARCA people, like, you weren't hired by an insurance company, you weren't hired by us, you weren't hired by Karen Reed, you weren't hired by anyone associated or supporting the defense of Karen Reed, right? Like, they can ask those questions, right?
Yeah. And the important thing is this. I mean, there's an even better way to do it. At this point, they all know who she is, obviously. But again, you go back in the timeline to, I guess, whenever they were actually engaged, which I think was in February or whatever, and say, in February of 2024, had you ever heard the name Karen Reed? No. Did you know anything about, the Commonwealth of Massachusetts versus Karen Reed? No. Did you know that you were hired in a criminal case where the allegation was at a police office? No. You ever heard of me, Alan Jackson, Bob Alessi, whatever, in February 2024? No. At the time you made your opinion and no. I had nothing to do with you until I learned from the federal government that you guys wanted to talk to me because their opinion is entirely exculpatory. If these guys are credible, the case is over, period, full stop. They can't win a conviction if anyone believes that these guys could be right. Again, don't have to be right, reasonably. Could that be the case? So I think obviously you learn from the first trial, you know what the cross-examination will be in terms of you didn't have all these materials, and they make these guys as credible as they can be. And then, it'll be up to Brennan to decide if he thinks the smoking gun is $20,000, a month or two after trial. And the fact that, one of the ARCA guys had the temerity to eat lunch across the street with the defense team that, I don't know, like brought him out there. And I mean, last I checked, even a witness has a right to eat lunch. I don't really think that's a hell of a big deal. And I don't think any jurors will either.
So I want to thank Melanie Little and the Cupcakes for being here. Melanie Little sent all our people redirected over here for Mark. She loves attorney Mark Bederow. I want to thank her for
Big
doing
fan
that
of
tonight. All the cupcakes. We got some other questions. I got a question from LTL that came in. He wanted to know, who do you think the defense should put on the stand first? Who should be their first witness this time?
So that's an impossible question to answer because you don't have any obligation to do anything. I'm not suggesting that'll be the case, of course, but we haven't even seen how the prosecution case comes in, how much it implodes, how much it doesn't implode. I'm not trying to deflect, but it's really, you need to see where this is going. I mean, there are some witnesses that they may believe right now, today, on the eve of trial, that they're definitely going to call, and 6 weeks from now say, we don't need to do this, we don't need to do that. It's really an impossible question. You have no burden to do anything. Part of being a defense attorney is you have one of the harder jobs, I should say, is you have to observe, react, go with the flow, adjust, where when you're a prosecutor, it's much more mechanical, methodical. We have to do this and do this and do this. And there's a lot more feel and in my view, judgment and skill, from the defense side. And fortunately for Karen, she's got people that know how to do that. So I'm not sure they would know. And there's no reason they should know who's going first, because if this case were to implode, maybe they call no one. I'm not suggesting that, but you never know.
I mean, you once cross-examined a police officer. I don't think you ever got to your defense, right? But like the one that they shut it down in the middle of the cross with the police officer. That happened to you, didn't it?
Yeah, that did. That was in the Manhattan DA's case in chief. And the case itself was only interesting because, it was similar to a cop like Michael Proctor, who sent really stupid, offensive, and exculpatory text. In his situation, he got caught because this dope was wearing his body camera and was holding his phone. And the client, bless her heart, picked that up in looking at the body camera and was able to really hone in, sharpen the image, and get us copies where we could actually read the messages. And that's a holy shit moment, obviously, and just absolutely destroy him with that, as well as some video which demonstrated that he had lied about his observations about what she was doing. And at that point, the DA just stopped the fight, threw in the towel, and that was that. But it happens. There are bad cops everywhere. There's still an empire, though. Most cops, I'm not anti-police in the least bit.
It depends on the individual, like anything else. There's good ones and bad ones and average ones. You know what I mean? It's like
Winnie
curve.
Winnie agrees, if you can hear her.
Well, Winnie? Hi, Winnie.
Yeah, well, she's in the other room. Come in here.
Yeah.
She stands guard. She's out.
She's watching. She's waiting. She's waiting for you to let her in.
She hears noise outside, and like most dogs, what do? They bark.
Barky bark.
Most dogs.
No, and Lola? Where's Lola?
She's not here.
She's not here right now.
No, she's doing her thing somewhere else. Usually she's in here on my feet, but not tonight.
Yeah, not tonight. So we got some other questions coming in too, but I want to ask about this motion, because you filed a new motion for Aiden Kearney. I want to ask you about a million things about Aiden Kearney, but I know there's guardrails that I really can't. But I know that you said you could talk about this one, this motion to allow him in the courtroom for Karen Reed, right? Tell us about that. That was just filed, apparently.
Yeah, I don't know that it's been docketed yet, but it's been sent in, so I assume it'll come out tomorrow. But there is a sequestration order in the case for witnesses, which basically means they can't be in the courtroom. There are exceptions that are often made, close family member or something, but it means generally that the witnesses can't be in there for the trial that does not involve them testifying. And it means that they're not supposed to watch the trial. Now, that makes perfect sense for a lot of witnesses who are very important. You don't want them tailoring their testimony. I'm sure you're familiar from the first trial. There are at least a few witnesses who are very keen on, I need to know what I said. I need to see this. Tell me what this.
Jen McCabe. And Matt McCabe, both of them did that a lot.
Again, there are witnesses, as you said, who are big on that, and you don't want witnesses like that or other key witnesses watching. Well, then you get someone who is on the witness list, who's a journalist, and who actually quite literally makes a living at the moment reporting and covering this case. Okay, so you know who we're talking about, obviously.
Aiden Kearney, Turtle Boy.
And he's
valuable. He's valuable for the public to get their information. I mean, even for us YouTubers, I rely on him. So many of us rely on him to get info and news, and he drives the story by the info he provides. Absolutely.
How the First Amendment works, and obviously a journalist providing information, particularly on a case like this, that is a very high profile case and is a matter of great public concern. I mean, there is a substantial part of the population who believes that Karen was absolutely framed and railroaded by corrupt cops. Now, I'm not stating I believe that or don't believe that right now. What I'm saying is there is no doubt that a substantial part of the population, particularly down there, where this trial is going to happen, who believe that. I mean, the town of Canton is on fire over this. They have a police audit that basically is supposed to come out tomorrow. That is the result of this. There is an international movement, if you will, Free Karen Reed, all of that, which generated specifically because of the large segment of the population who believes that she's being framed, railroaded by corrupt cops. You have at least one cop, the main cop, was terminated for exhibiting bias against her. I mean, you can't get worse for that in terms of supporting what the public, that segment of the public, believes. So obviously, reporting on this case is critical. And now you take someone who reports on the case and is extraordinarily critical of the government, okay, who is in fact the leading critic, if you will, that led to all of this by accusing them, in his belief, doing all these dastardly and dirty things, and other witnesses who he believes are lying, and a lot of people agree with him. So that's important. And when you have a journalist who is criticizing the government, that is when the First Amendment should kick in more at any time, when you have the government trying to suppress and stifle speech of a journalist who is specifically writing about and criticizing the very people who are trying to shut you up. Okay? That can be perceived by many as tyranny. That can be perceived as, something that you would expect in an Orwell novel, not in a courtroom in Massachusetts in 2025. So this individual shows up on the prosecution witness list. Now, again, there are different types of witnesses. There are witnesses like the Jen McCabe's of the world who are very, very important witnesses, whether you believe her or don't believe her, whatever your view of the case is. There's no way that there's ever a trial in this case and she doesn't testify. That's just impossible, right? So there's many witnesses like that. But what we find out here is they put him on their witness list to keep him essentially on ice as a rebuttal witness in the event that the defense opens the door by cross-examining a witness that leads to some kind of harassment, which somehow links Karen Reed to Aiden through communications. But when you get through the blah, 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 and 20 degrees of whatever, but this means that Karen had a consciousness of guilt because of whatever she and he spoke about and whatever Aiden did or didn't do. Okay. That's why he's on the witness list.
A long way to go. That's a long road to get to there.
So, and by that inclusion of him on the witness list, the Commonwealth of Massachusetts would say we should shut him up, stifle his speech, kick him out of the courtroom, no tweeting about this, no live shows about this. Okay, that works. We used this term before in like Stalin's time in the Soviet Union. Okay, that works in Castro's Cuba, Mao's China. We could go on and on. But the idea that someone like that should be kept out of the courtroom and have his First Amendment rights, and frankly, the public's First Amendment right to hear it, learn it, agree or disagree, shouldn't be the case. So, obviously it's our view that unquestionably his First Amendment right clearly outweighs this idea that the prosecution is going to call him. Now, are they really going to call him? I mean, what prosecutor is calling somebody who is so against them without the chance to talk to them under the theory that they believe he's going to somehow help them? And let's be clear about something. He would be called as a witness and give direct testimony. They can't just declare him hostile. Okay, you can't call a witness for the purpose of declaring him hostile or for the purpose of impeaching him. You have to have a real reason. And if they were to call him on direct testimony under this nonsensical theory that he's going to establish Karen's, remember, he doesn't even matter in this case, to establish Karen's consciousness of guilt on direct examination and have him explain whatever he did and why he did it, what prosecutor would do that? So look, when you look at it all this way, to us, this is clearly a stunt that is designed to quiet his speech. Now, it turns out it's not the first time that this prosecutor has tried this. Now, from the other side, this happened in the Whitey Bulger case. And that's public record. That's
with Howie Carr, right?
3 journalists.
Yeah.
The Bulger defense team put 3 journalists who understandably were very critical of Whitey Bulger in reporting on it. Now, why would they be critical of a, long-term gangster, killer, treacherous, weasel informant who has people killed? I mean, why would reporters criticize that? The point is they clearly would criticize that. And 3 reporters were put on the defense witness list in that case, and they had to fight and intervene. And the district judge, the U.S. district judge, overturned that and allowed them in the courtroom for obvious reasons, finding that this is, very speculative. I don't even know that they would be allowed to testify. But these are reporters. They're reporting on a matter of public interest. And, there still is a First Amendment. Okay. I know it's hard to believe sometimes, but the public still has a right to know. And then you get to our guy personally, which is this. This is his job. This is how he earns a living. He's allowed to earn a living and make money. Okay. If he is banned from the courtroom, in addition to potentially making a mockery of the First Amendment, you are infringing on his ability to earn a living, which leads to the real irony of this. The DA has given him protection as a witness under the Massachusetts witness intimidation statute. Okay. And if it turns out that they put him on the witness list to suppress his speech, that there's no real good reason to further the trial, but the potential witness suffers economic harm or emotional harm.
Yes.
This is
The
how
DA is witness intimidating.
that
Oh my
is
God. That is so true.
I'm
Oh,
noting the irony of that. I'm not saying they did it. The point
I
is,
know, but it looks
they
like that for the
they have
public.
weaponized that statute against people for throwing rubber ducks and doing nothing, and even against other people. And this is what they're doing. And then the last point that you just can't ignore is they tried to indict both of them in late March of last year, March 27th.
Yes.
Now, I don't know the exact date that Karen's trial started last year, but it was around the same time. Right?
Yeah, it was right before the trial. I remember this. Yep.
So imagine if they get indicted late last March, a week before trial, and it's on the front page of every discussion in the media in Massachusetts, and now the world thinks that the accused murderer already under indictment is now tampering with witnesses, conspiring with this guy. Okay. It's in the press. The prejudice to them is over the top. They're probably seeking to revoke her bail, right? And they wanted to try the case from the inside. I mean, it's a shit show of all shit shows, such to the point the defense probably would have been forced to ask for an adjournment. And given the way things go here, probably would have been denied just because that's the way it is. So they tried this and they failed. Then, with all that's been going on in the last week, with their obsession in getting, the smoking gun messages that they believe are on his phone that are going to help them, that you saw last week, and this is all in the public record as well. You saw reference to a filing by the special prosecutor in our case, which included some text messages between some lawyers and the client, which have nothing to do with witness intimidation at all. Absolutely nothing. It's not a crime for lawyers of someone to talk to, someone else. It's not a crime for Karen and Aiden to talk. That's normal. But there was another reference in there where they said, well, this matter is still under investigation, according to them, if you believe that or not. Okay. Now, you should believe them when they put that in a court filing. I mean, it would not be good if that was not accurate, which begs the next question. They're trying to offer consciousness of guilt evidence against Karen Reed based upon her alleged involvement with Aiden, talking about things that a grand jury already punted, but yet we could at any given moment continue to investigate. And in fact, we'll just say it, you're under investigation. Well, that raises another interesting question. If they're trying to introduce consciousness of guilt evidence, and the substance of that evidence is evidence that they're currently using as part of an investigation, it's basically using uncharged bad acts to try to throw it into this trial to establish her consciousness of guilt, which I'm not even sure that's even permissible or admissible, but that's an issue for Karen's attorneys to address because it doesn't affect us. But when you put all of this together, you can understand why we would take serious issue with the idea that, he should be excluded because the DA says, well, he could be a rebuttal witness for this, almost silly concept of we're going to prove Karen is guilty because she, God forbid, had conversations with this guy.
When do you expect to be heard on that? Do you think that that will be something that will be done quickly, or like after the jury selected? How does that work?
I would call this pretty freaking important, and something that ought to be dealt with, forthwith, and stat, because there's a trial starting tomorrow, and people like to cover trials. So it's not for me to play role of clerk or judge. That's for them. But I think obviously it's in everyone's interest that this be resolved toot sweet.
And I wonder if the prosecution's going to have any pushback on it. Any no affidavit. Maybe something. Maybe at a hearing they'll say, "Oh, we don't oppose it, but this is why we oppose it."
Look, accommodations are made all the time. They have been made for individuals. They've been made for Michael Morrissey. They've been made for the victim witness advocate. How come? How come? They're made for certain family members. That's fine. I mean, nobody, I think, would suggest, for example, that any O'Keefe family member who testifies ought to be precluded from the courtroom. I think that would be unconscionable. No, I think that would
I wouldn't like that. I think they should be allowed to be there. Absolutely.
Unconscionable to do that. The same way it would be unconscionable to kick out Karen's parents. So there has to be some degree of common sense. All right. But the big distinguishing trait here is him even existing on the witness list feels like nothing more than just a stunt and the latest in a pattern that dates back now really to the late spring, summer of 2023 going forward, as just a long-standing effort to do anything and everything they can do to just shut him the hell up. And the reason they want to do that is because they don't like what he says. And you can't regulate issues of speech that are content-based. And everything that is regulated with speech as it relates to this case is always content-based. All of the witness intimidation arrests are content-based. There's plenty of people on Twitter and who scream and yell at the courthouse who could be arrested based on the standard used by the Canton police and Mass State Police. They don't do it.
They're not gonna, because they're on the right side. They're on Michael Morrissey's side.
So this is a big test to see where we are and whether, the First Amendment lives, breathes, and functions in Norfolk County. We'll see. I mean, I expect it will. I mean, I have to think that common sense will prevail here, because it would be a disgrace and an outrage if you ban someone because you just don't like what they say. And I get why they don't like what he says, because he comes after them. But it's still America, and you're allowed to be critical of the government. And the reality is, large sections of the population, in fact, most of the population, based on what you see with, they have to make buffer zones double in size. They have to do all these things. You see these standouts or whatever these other things are, and all the attention. Most people agree with the position that he's been reporting and advocating on.
Absolutely. The numbers support it. It's a question. Did you happen to read the prosecution's motion asking Karen to agree to authenticate the Boston 25 or Vanity Fair, The Body in the Snow? That's the ID series. If he did, what does he think? What do you think about it? I mean, did you read it? I'm not sure.
No, I didn't. But that's going to be the prosecutor's, gaslighting way to say that I'm trying to bend over backwards to give you a fair trial and this and that. And this is going to be his version of saying, if you want me to take your lawyers off the witness list, then you need to agree to this, and then I will no longer need them to potentially do that. So it'll be interesting to see how the defense team handles that. I would expect there's a chance they will, but they're still on the witness list, which is a joke. The fact that Alan, David, and I think Liza is too, I think, because she was in these shows, that they're on the witness list with a straight face. If they get called as a witness, this is a mistrial. Okay? And everybody knows that. He's not standing up and saying, I call Alan Jackson as a witness. This case is, if you think it's a shit show now, it's like a whole new level for anyone to even attempt to do that. So I don't see it. I could see them agreeing to this, I mean, but if they don't, then we're in dangerous ground.
Let's say they don't call them as witnesses, which I'm guessing they won't. How does he use this stuff? How does Brennan even try to use any of this documentation, this video? How does he use it?
You use the people who made it. You don't need the lawyers to do that. I mean, you could call someone from Boston 25, and just say, is this accurate? Is this there's a million ways to do it. Or the defense to just, as to this narrow issue, could stipulate. I mean, the reality is if the DA can establish the foundation, which I'm sure they can, the statements that Karen made are going to be admissible. There's no way around that. I mean, they're clearly admissible as admissions by the defendant, assuming they're relevant. I mean, obviously, if they wanted to introduce a statement where she said, I had steak for dinner last night, that would be inadmissible because it's not relevant. But anything in which she's describing the incident, that's relevant. So, I mean, that will come in if they really want it to come in.
Right. Why would they put Karen's attorneys on the list, but not like Ted Daniel or not whoever, these reporters? Like, I don't see the lady from The Body in the Snow that interviewed me on the list. I don't see her, like she's not on the list. So why aren't they on the list? But the lawyers are.
Because look, you're dealing with an aggressive, needling prosecution. Okay. We just had serious litigation with a straight face over why they ought to be entitled to look at David's phone and text communications to the extent there were any with his client. Okay. We just spent a week last week where they're fishing around to see what, they think are very important communications between, Aiden and Karen that are going to show her consciousness of guilt. You've seen them put the lawyers on the list and say, we're going to do this. You've seen them try to exclude the ARCA witnesses. You've seen them. I mean, this is the most aggressive, not in a good way, by the way, aggressive prosecution tactics you'll ever see. I mean, you're correct. They could prove it through those types of people. They don't need her lawyers to do that. But they could stipulate to some of this just to, make it a non-issue. But that's between all of them and the DA.
So I'm just reading some of the chat. If people have questions right now, this is a good time. You can ask some questions. I'm definitely checking out the chat. Mark, is there anything else that we didn't bring up tonight that you wanted to bring up from the motions, the rulings, the trials, or even Aiden for Turtle Boy?
I mean, I have no agenda. I'm just here to answer and discuss. I mean, whatever you want to talk about is fine, assuming it's appropriate, of course.
Definitely. There is so much that happens. I always feel like I'm missing stuff. Then I think of it later. But I my list, we got through things pretty quickly. Without super chats, things move more quickly, I notice.
Yeah. How about that?
Yeah. Maybe we don't have to do like 3-hour shows anymore.
Or you do it.
What is it?
I said, however you want to do it, it's fine with me.
Yeah. Someone says Aiden's new ruling. What is there an Aiden's new ruling? What are they talking about there? There was a comment here. Aiden's new ruling. You find it here.
It relates to protective order that was litigated last week for the materials that perhaps the special prosecutor will be required to turn over to Brennan, related to the phone hearing that you saw last week in front of Judge Sisitsky. He issued the protective order in part, which means that they are forbidden from sharing it with any third party. So that's a win. I'm not going to tell you it's a, end of world, never seen anything like it, but, obviously, I mean, that's appropriate. There's no reason why those should end up, on the internet if they're not discussed in court or not the subject of any filing or anything like that. So, yeah, no, we're pleased with that.
Question, any idea on the motion to dismiss for Aiden's case?
We're still waiting. It's been a while.
As another question, auditory storytelling says, if Brennan asked the ARCA witnesses about what is that? The $20, wouldn't that open the door to the reality that there was a first trial?
I mean, you'd arguably, yes. I mean, you have to work around that. She's not going to say that opens the door, but in all fairness, and this is important, timeline matters, like we talked about maybe 30 minutes ago, in terms of when they were engaged, when they got their opinion, when they even heard of the defense, and when they sent the bill. And I think it's important that I agree with the comment that the jury, number 2, in theory, should know that they got the bill because the witnesses' firm believed the case was over. Now, how do you do that? How do you say that? That's a very good question, and this potentially gets messy. I just can't wrap my hand around the fact that these guys are going to get questioned about, a very ticky-tack bill sent after the fact. And then they're going to explain, well, yeah, we were told by the, unnamed person who hired us that we could do that. And it's just lodging, food, travel. It's not even for, what our normal bill would be, which would be off the charts. So, they need to tread carefully with this.
There's a question here that I haven't seen before. Did you see the combined witness list where at the bottom there is an asterisk, and it's like if you call the defense, you're breaking Rule 3.8, and we're going to fight you.
Right. Well, 3.8, and this is the rule in Massachusetts. It's also the rule in other jurisdictions as well. That's a rule that specifically applies to prosecutors. I think it's titled something like Special Responsibilities of a Prosecutor. And it basically says you got to behave. You can't bring charges that are not supported by probable cause. You can't do things that could disrupt the trial for which there's no good faith basis to do. You can't subpoena a lawyer except in limited circumstances. And that's what they're talking about. I mean, they're going to say, if you subpoena us, we're going to fight you to the death because, the rule basically says that unless you have a reasonable belief that it's the only way you can get something, you can't do it. And if it's about these TV shows, you've already made the defense point 5 minutes ago. There's plenty of other ways you could do this. You don't need to call us. One could argue, were they on the witness list as a stunt for the press? Maybe, I don't know. But, Rule 3.8 very specifically warns a prosecutor, don't get cute trying to subpoena lawyers on a case unless you have a damn good reason to do so and you have no other basis to get important evidence but through them. So that's it. I can't envision a scenario where he would even do that or try to do it because it's going to lead to a mistrial. And the judge is never going to allow it because that's the last thing she wants.
Imagine if he caused his own mistrial. That would be amazing. Mark, do you believe the Fed case has really ended? Good question.
I don't really talk about the Fed case. I don't know.
Guardrails.
Guardrails. I saw a lot of people were, really hyper focused the other day on a filing where,
they mentioned, yeah.
I just found out that, their file got subpoenaed, and it said it was ongoing. I have no knowledge what that means. I'm not going to speculate, but the idea that the feds would subpoena their file very well could have been to get evidence to give to the ARCA guys. I don't know, but I have no idea. Announcements have been made. Some people believe it, some don't. I have nothing on that.
Question: do you think someone on defense is watching or reading the old trial transcripts of Brennan's cases?
I don't know. I don't know what they're doing behind the curtain at this point, so I couldn't say. I think it's natural curiosity. It's kind of like the art of war, know your enemy, that kind of thing. To be curious about his style. If they had videos, that would be even better than transcripts. To be honest with you, I don't know if those exist. There are certainly transcripts that are out there, and I'm sure they're learning as much as they can. So I would think to some level, they're trying to understand their opponent. Yeah.
Good question here about the last trial, the testimony. Can they use it to impeach witnesses this time? And do you think this is going to happen a lot, where they're replaying testimony from the grand jury from the first trial a lot? Is that going to happen a lot and kind of slow down this trial?
Well, so the first answer is, yeah, they can use prior sworn testimony if there is materially inconsistent and relevant discrepancies. Of course they can. I mean, that would be totally appropriate. Is it going to happen in this case? To tell you the truth, I hope it happens a lot more than it did in the first case. I mean, if you want to be somewhat, armchair quarterbacking, which you want to be very hesitant to do, I think there was a lot of meat on the bone that was left in really going after some of the prosecution witnesses with respect to their prior inconsistent statements, whether it be sworn or even just statements made to various police officers. I would think that becomes very, very important. Again, reasonable doubt. If someone like Jennifer McCabe has an ever evolving statement, and every time she talks, it just turns and twists and is not consistent, you need to let the jury know that, and you need to let them know that it's always the other guy's fault, because her credibility is important to reasonable doubt. It's not so much third-party culprit stuff, but if her credibility is more in question, then jurors are going to be less inclined to believe that Karen said, I hit him. They're going to be less inclined to believe she said, my taillight. I mean, you could go on and on. This is all about reasonable doubt. So I think it would be very wise to really pin down all of them more on those nuance and inconsistencies, and also some of the first responders and whatnot. I mean, I think those turn out to be pretty important witnesses, and words matter, and I think they need to really draw it out.
We had a question about if Aiden was ever gagged, could someone like LTL Brian take over his channel in his absence? That would be allowed, right? They would allow Turtle Boy TB Daily News to continue. It just wouldn't be Aiden. It would be someone else, right?
Well, I mean, I don't want to get too much into the weeds on talking about, how would a client, with a gag order. I mean, I don't know that would be wise for me to talk about.
Right.
If an individual is gagged, that individual is gagged. I'm not suggesting that's the case, but, I don't know that I want to go down those kind of rabbit holes and discuss what people do in that very unlikely situation.
Definitely. There's one. They're asking about Mello. They want to know, does Mello just get to disappear from Turtle Boy's case? I mean, he kind of has, right? I mean, he had an illness, and is he recused? Is he still part of it? You guys actually wanted him off the case, didn't you?
So we moved to throw him off the case the minute I got involved, because he is a material witness. And our position, and this is all publicly filed, that he was a material fact witness, like literally to allegations on the phone while an alleged crime is happening and whatnot. I mean, that's very rare that a prosecutor allows himself to be talking to witnesses and, in the middle of the night and doing things that, make him a fact witness. That was back in late summer, early fall. It's now April. I have never seen Ken Mello. I have never spoken to Ken Mello. Have never seen an email from Ken Mello. So he was scheduled to testify at a hearing. That's been pushed off for reasons I won't get into. So at least in a formal sense, he's still on the case. Obviously, this has to be dealt with because we fully intend to kick him off the case and subpoena him and have him as a trial witness. So we just, we're going on 8 or 9 months of an inability to do that. So, but before we can do anything, we would need to have him disqualified so that we could do those kind of things.
Kind of answer this one. I mean, you don't anticipate a couple of motions to reconsider Michael Easter, right?
No, I don't. I mean, I don't see the point. And again, if it goes well, the judge is just going to say you don't need it. If it goes terribly, I'm not sure how that's going to change her ruling. I mean, the fact that a witness disagrees with Alan Jackson about whether this was a proper investigation or not is not necessarily a reason for the judge to reconsider and say, I'm going to just keep doing this. And I've decided to change my mind because I think, you have a right to do this. I mean, she made a ruling. I don't see what would lead her to revisit it.
It's another one about, do you think the defense attorneys could be on the list just to put pressure on Karen to testify? That's not really possible.
No, one has nothing to do with the other. The larger question, the threshold question, is why the hell are her lawyers on the list?
On the list, yeah.
Is there a good faith basis to do that? And that's concerning. Okay, it's not normal to put the entire defense team on a witness list a couple of weeks before trial without raising an issue. Now, I know what they would say. Well, this show occurred late. But they were already planning to use the other interviews, right, from Voss and other weeks ago. Why didn't they say anything then? So, and again, I think there's a pattern here of, going after her lawyer's communications with his client, subpoenaing lawyers because of the TV stuff, trying to exclude exculpatory ARCA witnesses. I mean, this is not normal stuff for a prosecutor to do.
A lot of comments. If people have questions, I'm just trying to read them all. There's so many comments. I want to thank everyone who's been throwing out comments and questions. There's one. Karen Reed is so guilty. Why is Commonwealth doing everything possible to take away Karen Wright's right to a fair trial?
I don't know. Again, the Sixth Amendment is an interesting amendment, and the 14th, they talk about the right to present a defense and due process, which in English just means you have a right to defend yourself. You have a right within reason to challenge evidence and introduce evidence. And really, the only reason that you should not be permitted to do that is if it's just way out of left field. It's not relevant. There's something sketchy going on, those sort of things. Trying to call the ARCA guys is that's called normal. They're helpful witnesses. Trying to call all these other experts that would support what they're doing, that they keep trying to exclude. I mean, you go back to like the Richard Green thing. That was the real first sign, I think, in terms of saying, we're back in crazy land. I mean, they had experts who disagree with Rick Green. That's normal. It's normal in litigation for one side to hire an expert and the other one, and then you throw it at the jury and they do whatever they do. But, you know, in this DA's office, or the current permutation of this case, they decided, well, our two witnesses are correct. Theirs is a moron, so you shouldn't even allow him to testify. That was absolutely, as a legal exercise, batshit crazy. I mean, that is one of the most frivolous motions that I think I've seen in 26 years, to literally say, I say, without an affidavit, without anything, I, the prosecutor, say your witness sucks, so you don't get to call him. It's like a bad movie. I mean, this is not how trials are conducted, and you've seen it with other witnesses, and it just goes on and on. And if they have confidence in their case, they ought to present it, and God bless them if they're correct. And if somebody committed a terrible crime and the evidence establishes their guilt, then, you know, that's how the system works. But you can't deprive Karen of defending herself, which is essentially what they're doing, while they're saying at the same time, my biggest concern is to make sure she gets a fair trial. Which is it? Like, you can't, you know, you should judge deeds more than words. So the words are very empty here. The deeds are very telling.
I got a question about something we haven't got a chance to talk about, which is the jury, since trial one ended, has been an ongoing like concern, like discussion. They've been involved in the retrial now, like just starting with, you know, was there jury tampering? What did the jury actually find? With the defense appeals, you know, to the federal level, all of this stuff's been going on. And now you have a juror from trial one who was an alternate, who's now Karen Reed, like submitting to be a Karen Reed defense attorney. If she is, I'm guessing she's going to be allowed because she's a mass lawyer. She's part of the bar. How do you think that might help Karen to have her, a former juror from trial one, as part of Karen Reed defense team?
So in the first instance, there's no way to not allow it. I mean, if you are a licensed attorney in Massachusetts, which, you know, who knew that was the key, right? But if you are a licensed attorney in Massachusetts and you have no other reason that would preclude you from joining, then you get to join. Now, this is really weird. I mean, this is so out of left field crazy that your first reaction is there has to be something off here that could keep it from happening. But the more you think about it, when you come down from this is crazy, it's a non-deliberating juror, okay? Licensed to practice law in Massachusetts, so it's permissible. I don't think there's anything that anyone can do to stop it. In terms of what effect it will have, this may be the minority view, literally nothing. You know, this is a murder case, very sophisticated murder case that takes a certain experience and skill set. And I don't think anybody believes for a second that, you know, a lawyer, obviously with 3 or 4 years of experience, been non-practicing for a couple of years, is coming in to tag in to like take on 30 witnesses and, you know, do all that. I mean, that just is not, there's no way, right? So the question becomes then what's the point? I'm assuming the point is to just pick the brain of a juror and keep it privileged, right? I mean, it obviously you have a privilege, and that's fine. You can do that. The only concern I would have is this, by all accounts, was a juror who's with them, right? There's no issue that this is someone who doesn't believe what it was. if you're picking jurors' brains in an ideal situation, you want to pick the ones who are against you and try to figure out what's the problem here. So I think that's probably the role, or, you know, if there's legal research or whatever, you know, certainly that can help. The more, the better. But I think people need to be realistic. I mean, this was, again, very bizarre and a really hot topic last week, but I think you need to be realistic about what this means and what it doesn't mean.
It's interesting because it seems like ever since that first trial ended, all we've heard about is the jury from trial 1, even going into trial 2 here, like, you know, the Ronnie interviews, all these interviews that dropped, and, you know, how do they rule? How do they actually? It's just been so many in the appeals, and now we have this. It's just interesting.
But the thing is, and this is, again, this is a non-deliberating juror, so there's the knowledge ends like at the end of summation. So you're getting feedback for how the case went off and whatnot. What you're not getting is what in the hell happened.
What are they thinking in that room?
I mean, you're not getting access to that.
Nope. That would be interesting. That would even be, but that probably would be allowed, I guess. I don't know.
That might be a situation, but it doesn't matter because it's not on the table.
Yeah, not on the table. Actually, we asked this question. It's this one I want to put up.
We did that one.
We did that one. We did them both.
Yeah.
I don't know. I thought I had 2 up that we were going to ask. There's a lot that coming in. I want to thank everyone for all the questions tonight. I know I got a few more in here. I mean, let me just scroll up. 1 second. There's one. Hey, Mike and Mark, during jury selection, could the defense ask potential jurors if they know the standard operating procedures for murder investigations in the jurisdiction and other jurisdictions and why they exist?
Probably not. That's probably a little far afield. Also, remember, in this case, you know, the way this court does it, this is all at the bench, and, you know, the judge is the point guard and not letting the lawyers take the lead. I mean, certainly where I come from, legally speaking, you know, the judge lets the prosecutor ask the questions. If they spin out of bounds, the judge can sua sponte, say, we're not doing that. The defense can object, and you switch sides. And again, you brainwash and get rid of the kooks. Just brainwash and get rid of the kooks. That's going to be much harder to do. Much harder to do here.
Yeah, it's funny. This is a good comment. They say, Sarah says, I wonder if she, you know, talking about Victoria George, if she will be handling communication with the public and the 9 interns they have running research. I didn't know they had that many. That'd be interesting, huh? They have 9 interns. Is that true?
Yeah, that is true. I'm aware. I've been aware of that. Yeah, no, I mean, look, obviously, you know, very intelligent law students in the area are attracted by this and are, you know, similar to whether lawyers or other people in the public, they feel there's an injustice going on here and want to help. And, you know, from a law student's perspective, what better case to see how the sausage is made than on something like this? So, I mean, from a law student's perspective, this is just a dream case to get involved in behind the scenes.
Question came up a couple different ways tonight. Here's one from Kindred Spirit. Says, what can Mass residents do about this waste of our tax dollars? I cannot believe the extent they are going through with this and the money.
Well, I think there's 2 things you can do. 1, get the hell out of there, or 2, vote the bums out.
I was thinking about that. I'm like, do I really have to leave the state?
Well, option 2 is vote the bums out. I mean, but it really, those are the 2 choices.
I hope people start voting. There's an election coming up in Canton. You can vote on that one coming up April 8th. It'll be a week from today, tomorrow, week from Tuesday. So that's one of the next elections people can vote on. Vote some people out. Here's another one. Does this case make lawyers not want to practice anymore? I can't imagine how frustrated the defense must be. Do you think the defense gets frustrated like that, or are they like
You
amped
have to
up? How do they handle this?
you got to understand how high level criminal defense lawyers are wired. Okay, it's your career that you've chosen is literally the business of misery. Okay, nobody ever wants to deal with you. Okay, and you see a lot of injustice, you see a lot of things, and certainly you come around and then you get a case like this. So can you get frustrated? Yeah, in the sense you kind of you see these decisions today, you roll your eyes, you might make a few comments amongst each other, but it's motivating. I mean, you're actually it charges the batteries, makes you want to go, and the way you approach it is losing is not an option. I mean, there's you don't want to even think about the possibility that this could happen on my watch. You think somebody who's wrongfully charged, who's actually innocent, certainly not guilty based on the evidence, the way you see it, you can't have this going south on your watch. So it's motivating. I mean, if you choose to do this kind of work for a living, and it's high stress, it's high intensity, it's often high profile. You're often, in the fishbowl for people to see. And, like some of the online wackadoos to, throw comments here and there about every single thing. It's not for the lighthearted. So no, they're not going to be frustrated where it affects them. People like us, you turn the frustration and channel it into energy and focus to win. So no, I think they're highly, highly motivated to see it through, to finish the job. And it's things like that. If you remember several months ago, when a lot of people speculated, after the first trial, Alan's going to be out of there. Now, I didn't know any information at that time, but anyone who understands, again, how you're wired and how someone like that is going to be wired, that there's no way that was ever a consideration in his mind. And the reality is, the only way that a lawyer in a case like this would be out of there is if the client, who has a right to do whatever they want, would say, well, I don't want you there. And that would never happen here. So no, this is motivating.
Because people, I remember that you said, no way, he's coming back. Yeah. This question came up. This is something Nan said the other night too, or other day she was on the show. She was basically saying like that the defense should play harder with Jen McCabe and even some of the other McCabe's. I think you mentioned this tonight as well.
I've said,
can they just make it that Jen can't keep asking to see the black and white? What do you think?
Well, one of the things, I've said this to you weeks ago, months ago, I think even 20 minutes ago.
Yeah, you did.
There is a different way, in my view, to handle Jen McCabe. And, it's your way or the highway with someone like her. And not because, you're going to yell at each other. You just have command and have the inconsistent statements, and you just do it that way and lock her down. And yeah, so I think to some level, you have to be very tough with witnesses who can be very difficult. And, look, she's very lashes out, pushes back. That can be difficult, looks at the jury, but in doing so, she makes mistakes. She says things that actually, if you go back and look, it's not helpful. And look, they get a chance to refresh and go after it again. They have the prior transcripts. They have all this time to deal with it. And I would imagine that the cross of people like her will be even better the second time around than it was the first time around, just because, it's not their first dance.
Question from Catherine. She says, wouldn't that attorney have been on the post-trial jurors text chain? Maybe additional info.
I don't know. Again, I don't know what happens to alternate jurors and jurors on this case and who stays in touch. I would be speculating completely. I don't know. Maybe. I mean, maybe not, though.
All right. I think we got we answered a lot of questions tonight. I'll ask another one. Why not? If Hank is bringing up interviews Karen did during first trial, can that open the door for the defense to bring up the first trial?
No. They'll allow him to get into the date of what it is. That's not going to open the door to the first trial. But then there's kind of, there's the pink elephant in the room the whole time here. Who the hell sitting on that jury is not going to know that there was a first trial? Where are you getting 12 people seriously in that county who have no idea? Where are you getting people who don't know what happened with, the alleged acquittal versus non-verdict in the first thing? Where are you getting people who don't know that, there was some kind of federal investigation and that's where these ARCA guys came from? Maybe not everyone will know that, but a lot of people will. Everybody's going to know going into the trial when they hear the witness list. They're going to hear, if you look at the witness list, it says, Trooper Michael Proctor, and they're all going to look at each other and say, wait a minute, that guy's not a trooper. He got fired. That's former trooper. I mean, they know all this. There's so much saturation of media this time around that this is just one of those things. There's no way around it. So they're not going to be able to mention it, but they all know about it.
There's one that just came up. They want to know if the defense can keep referring to police procedures handbooks.
Well, if they have them, if the Canton Police and the Massachusetts State Police have something, I mean, like in New York, the NYPD, I mean, I have a copy of it. I don't think it's not here right here, but they have something called the NYPD Patrol Guide. It's now online now, but I have the old version. I mean, it's a book that's like this, where it literally has every rule and regulation about what a New York City police officer is supposed to do, right down to their physical appearance, what it means to be fit for duty, what arrest paperwork, you name it, it's in there. And that's a common thing that we use when they screw things up is make sure, are you familiar with the patrol guide? Did you study the patrol guide? If it's a sergeant, did you take a test where you have to, ace the patrol guide? And, did you do it in this way? So I don't know if the Canton Police has that based on, I mean, let's be honest, what you've seen here. But if they do have it, then yeah, they should use it. Same with the state police, because it damn sure did not conform to whatever guides they have. I mean, and that's just for a lawyer's perspective who does this for a living, maybe not necessarily a layperson juror, but for a criminal lawyer to see the way the Canton Police and Mass State Police handle this in those first few days, I mean, is just whatever the word is after joke. I mean, it's beyond a joke. It was embarrassing and frankly, very disrespectful to, a deceased police officer.
Question, I think I know how you're going to answer. They want to know if the defense should go harder on Paul O'Keefe, knowing some of the things he's done.
Well, the first question you ask for cross-examination is, am I doing cross-examination? And if I'm doing it, what am I asking? Because it has to be relevant, right? I don't need to waste time. I mean, everybody knows about all that stuff. How is that relevant to anything he's going to say in this trial? How is that endearing Karen's defense team to, in the presence of jurors, even attempting to humiliate him? I mean, I have no opinion on what he did or didn't do. It's not my business, and I don't really care. But I don't think, as a lawyer, cross-examining him, I mean, if you go back and look at his testimony in the first case, I don't know that he's even needed as a prosecution witness. I mean, you know, there's a few things about going back to the house or this and that, but there's a school of thought that says you don't even have to cross-examine him. And if you do, it's like 3 or 4 questions. So no, I'm not examining him about, you know, his physical condition at a first trial. I'm not cross-examining him about his, you know, perhaps poor choices in his personal life recently. I don't think it's relevant. I don't think it would be a good look. And I just, you know, he still lost his brother. So I don't know, what are you accomplishing?
I would not want to see that. I don't think anyone wants to see that.
There's not for this. There's no point in that.
Yeah, there's nothing to be gained on it. Just make us feel awful, actually. Kyle Wells says, is there a point the Commonwealth throws in the towel with regard to prosecuting this case?
I think it comes down to politics. When is Morrissey's election? I mean, if he's DA, I mean, I think he'll like go down and sink with the ship with his sword raised high until somebody tells him you can't do it anymore. I think if there was a new DA, I think one of the first things they would do if there's a hung jury in the second trial is make the right thing. We're going to reevaluate. And then within 20 days would say, we're done here. So to me, it really comes down to, do you have the same district attorney's office who, frankly, I think is making a disgrace out of this? I think they're embarrassing themselves on a daily basis. They are just wasting taxpayer money. They still can't even answer why they need special prosecutors on everything they do related to this. Politics.
Funny, I'm getting people calling me on the phone, leaving voicemails with questions. I didn't even put the phone number up tonight. All you got to do is put it in the chat. You don't have to call. Just tonight we're doing right in the chat. I know there's a lot of comments and it's easy to miss, but if you want your question asked, the best way, just keep putting it in the chat and we'll try to get to it. I really appreciate all of your time here, Attorney Bederow.
It's fine.
Answering all these questions, because we have had a number of questions coming through here. And this is one that we haven't asked yet. We kind of have in the past, but why does Bev say this is a new trial yet she makes rulings based off the first trial?
I have no idea intellectually this concept of this is a new trial, so I just revisit everything like it didn't happen. Normally, you know, you have this thing called the law of the case, and the same rulings generally would apply unless there's some reason to change it. You know, this idea that I allowed the ARCA people at the first trial, you know, or any of these witnesses, like Green cleared a hurdle. He was allowed to testify, and then we waste all this time. Dr. Russell is another example. Although they, you know, I know they tried to say she tweaked her opinion, whether that's whatever, but to rehash what's already been hashed like that because it's a new trial is a waste, in my view, of resources. It doesn't serve any purpose. A lot of things. I don't know. And then there were things that were just not done that were new, you know, like the motion to dismiss is a perfect example. You know, it was never made before the first trial. It was made recently. And there was a lot on the table that I think most legal people who do this for a living, not all. I had an interesting conversation with a retired judge in Massachusetts who I respect very, very much, who disagreed, and that's fine. But most people would say how in the hell there wasn't an evidentiary hearing on the motion to dismiss is just mind-boggling. And why a judge wouldn't want to know the answers to, you know, why did Proctor do what he did? How is it that Lally didn't know that there was Sally Port? What is going on with the juror? All that stuff. I mean, I think, you know, there should have been a really deep factual record and then factual findings and then a decision, and then, that's that. So this whole first trial, second trial, we do do-overs, but not on this, but on that, it makes no sense to me. I have nothing on that.
Do you think that strategy of not allowing some of the latest witnesses will actually propel the defense to hit even harder with what they have right now?
When we say not allowing some of the latest witnesses, I mean, other than the FBI agent,
Michael Easter, I think, yeah.
I don't think it's going to make them hit harder. I mean, I think they're going to hit hard anyway. I mean, these are sharp-elbowed people. These are not shrinking violets. These are, ex-big city prosecutors who have prosecuted and defended high-profile cases, primarily. Not all of them, but some of them. And I don't think there's any issue based on the judge's ruling that they're going to let up, or not finish what they need to do because of the judge's ruling. No, I would expect them to come out like gangbusters and do anything and everything within their power, as long as it's ethical, to win. And that's what they signed up for, and that's what I'd expect they're going to do.
We get a question about Bowden defense. They want to know, what does the Bowden defense mean? What does the Bowden defense mean?
It's just a form. I mean, I don't even again know why it needs a name and a formality. I mean, you have it in every state. It's a common thing. You are attacking the police investigation. You're attacking the competence of it. You could be attacking the integrity of it. And you're arguing that leads or could lead to reasonable doubt. But that's in every case. I mean, obviously you have a right to criticize the police, what they did. You should have done this. You didn't do that. If you think they're corrupt and you have evidence to support it, you can certainly do that. They have a gift in that regard, given what happened to Proctor a few weeks ago. I mean, without more, that's substantial evidence that would support this kind of defense. They're going to attack the police. They didn't secure it. Nothing will change, for example, just because the judge didn't allow this Easter guy to testify. They're still going to say, why didn't you secure the crime scene? Why didn't they take photos? Why can't they do a chain of custody? Why are they using solo cups? What, all that stuff. I mean, that's not going to end. Why, does Proctor fill out search warrants that just conveniently always have the wrong time? And why do they claim first it was a typo and a scrivener's error and all this? It's not a typo. If you look at a keyboard, he didn't miss it by one number. It's all over the place. That's not a typo. I mean, things like that. So a Bowden defense is just attacking the police investigation. And if ever a case was tailor-made to tee up a Bowden defense, this is it. I mean, the police work in this case is absurd. That's how bad it is.
When Allie is on the stand again, can the defense question her about the timeline and Colin?
Well, I'm not sure she's on the witness list, actually. And at this point, given the ruling, I'm not even sure how far down the rabbit hole anybody wants to deal with Colin at this point. I mean, I don't know if you're even moving the ball forward, running the risk of the judge interrupting and saying, come up and what are you doing? Why are we talking about this? I mean, look, you're not going to get into like bang, bang and all that stuff at this trial. It's just not going to happen. Okay. You're not going to be talking about bloody knuckles that, for the first time in history resulted from, falling on ice and landing on my, clenched fist. As ridiculous as that sounds to any reasonable person, that kind of stuff is just not going to come in. So the question is, what are we doing with Allie McCabe and Colin Albert? I mean, that they've become unimportant in the grand scheme of the case.
Could a knowledge of police procedure be asked of potential jurors?
I mean, you have to be careful in what, again, the judge will allow. I mean, she's not going to allow you to run a fact check on a prospective juror. I mean, you could ask a prospective juror in evaluating credibility in this, do you find that, is it important that they follow procedure? Things like that, I think, are fair, but I don't think the judge is going to allow a Q&A on any particular juror about your direct understanding of procedure. Now, if you get a police officer, there might be a little more leeway in terms of that. But again, go back to how jury selection is being conducted. They're not asking the questions. Every question is being funneled through the court. That is a huge, huge disadvantage. Because you can't brainwash. You can try to get rid of the kooks based on certain things, but you're being deprived of your real ability to connect with them, get into them, really observe their demeanor. Also, when you do it one at a time at the bench, you're also missing something also really important when you're picking a jury. You want to see how they're reacting to each other. Like, for example, if you do jury selection in the normal way and you fill up a box, one of the things you'll do is say, sorry, Mr. Crawford, you have the misfortune of looking at me, so I'm going to start with you. And, you're making a joke, and now I'm asking a question, and now I'm saying, okay, so Mr. Crawford said this. What do you think about that, Mr. Jones? You're like moving around. You're seeing how they interact. That's not happening here. None of that is happening here. And that's awful.
Let's think that's not good.
No,
Massachusetts does things funny.
You want to, as a lawyer, try to connect with the juror, see who you do connect with. You want to read body language. You could be talking to one juror. You want to see how the other ones are reacting. You talk to a juror who says, well, I think, if she doesn't testify, then she's guilty. If she gives you like the Wendy Murphy speech that we talked about a year ago about, the prosecution ought to be allowed to call her as a witness. Remember that? Like that was her big.
Yes, I do. Yep.
Wow.
The prosecutor's gonna put Karen Reed on the stand.
Right.
Which
the point is that imagine, one of the jurors is talking like that. And, again, one of the things of jury selection, I want to get rid of the kooks. But if you're having that conversation with, this juror, and you see a juror 3 seats down, do one of those old Parker Lewis head turns, like their head like snaps and they look like, what the hell are you talking about? They're making faces, rolling their eyes. You're making a mental note. I like that reaction. This is somebody who at least seems to understand. When you start doing it one at a time at the bench, there's no personality involved. It's just the judge essentially droning on and on one at a time. It's just regrettable that that's how jury selection, because jury selection is really important. And when you have real lawyers who are really skilled, you're really taking away a real skill at a trial like this. So I think it's unfortunate.
Here's one. This is an interesting question because I noticed that you used the word grave concerns in one of your letters recently. And we all noticed that Michael Morrissey used grave concerns in his hostage video, and then Judge Kearney famously used grave concerns, and you've now quoted grave concerns in one of your writings. What do you want to say, Bederow? I'm sorry I interrupted you.
I just said he in his email from his personal account that he sent to all the judges, that's been much discussed and led to this issue over, private email use, where he was discussing, his grave concern about, a certain blogger in his mind learning about what happened at a public court proceeding. That was also a grave concern.
I think it's interesting that they use similar language like that. The judge and the DA. It's kind of interesting.
I don't know. There's a lot of coincidences, but I'm not sure. Unfortunate word choice on that is, I don't know. That's so much for me, I think. Oh, you're
Well,
silenced.
yeah, I'm muted.
It was
It's
bound to happen.
tough for us to know if we're being over paranoid or not. You know what I mean? It's like
I'm not getting excited. I mean, look, is there a comical element to the fact that there's a lot of grave concerns in Norfolk County? I mean, I can tell you, I've got a ton of grave concerns about how they do things in Norfolk County, but I guess the word fits.
it does.
But that's all.
We have lots of grave concerns now. Every day I have another grave concern about this trial. Kathy asked, "Will Mass State Police again be security for the jury in the upcoming trial?"
Given where we are and the fact that there were apparently no issues of any concern officially, I would assume so. I mean, I don't know I don't know that there's a reason not to, given that officially there's no concern here. There was nothing that anybody found was any wrongdoing at the first trial. So logically, I don't know why that court system would not allow it again. Now, anyone associated with Karen's case, I mean, why Fanning was in charge of security, whatever he did or did not do, that can give the appearance of something going on that's just an own goal. It's an unforced error. Why would you do that? He's involved in these cases. So if nothing else, can you please find someone who doesn't know anything about the case and is just doing their job? I think that would be better, obviously.
I was just about wrapping up. I got a couple more. I want to thank everyone for all their questions tonight. Sorry couldn't get to all of them, but we tried. We did answer a lot. Only in Canoni Court asked, "Can the defense challenge any of Bev's no metadata required rulings on evidence?"
I mean, if you're challenging that, you're in a bad place, obviously. It's not going to be the strongest issue on appeal, but if you're doing an appellate brief and you're throwing in this general, death by 1,000 cuts, there were so many unfair rulings that prejudiced the defense, I would assume that's one that you would throw in, but that's not the kind of thing that's going to get an appellate lawyer all jacked up to think that we have a winner. But I mean, it certainly seems that there's no good reason to have denied them metadata, particularly as it relates to the Sallyport stuff, which could have really clarified a critical issue, to wit, what the hell was going on with the video. And so, I mean, I think that's regrettable that she didn't see that as a much more important issue, because it really is important.
June asks, "Can the party use any of the grand jury tests?"
I assume that means testimony. You can use it to the extent to impeach. It's a sworn statement, and if somebody says something materially inconsistent at trial that was different from what they said in the grand jury, then you can absolutely use it to impeach them. Yes, assuming there's a reason. You can't just offer it as evidence, but it's a prior sworn inconsistent statement, then you should use it if it's a material fact. Yes.
Excellent. I want to thank you so much for being here tonight. Attorney Mark Bederow. Mark, always good to have you on the show, and just people are really loving it tonight, all the questions that you answered. Anything else that you think that, especially protesters or supporters of Karen, do you think that anything that you want to tell them tonight? Because this is the eve, and some people, stress is high on, both social media and everywhere else. People get very intense about this. Any final words you want to say on the eve of Karen Reed's retrial here?
Yeah, I mean, we've talked about this before too, not even just literally during trial, but during a lengthy, highly challenged, intense criminal case. The outcome here in the trial, it's a war. I mean, you're going to war, but in a war, there are many skirmishes and there are many battles and there are also many lulls. Tomorrow and the next week or so is going to be a lull, by the way, for your interest in this. But people who go so high and so low with every single motion or every single ruling, you're just going to drive yourself crazy. It's not how the lawyers are. Yeah, they're going to roll their eyes at certain things, but they're not freaking out because there's no Easter. They're not freaking out because Colin, gets a pass in their eyes or whatever. You keep your eye on the ball. You're used to judges who rule against you all the time. That's the nature of criminal defense. It happens more often than not. And I don't think it's healthy or wise for anyone to assume or keep score on every minor thing that happens throughout the course of a trial and thinks all is won or all is lost. That's just not how it goes. Obviously, you can tell how there's a feel if there's momentum and witnesses are falling apart or a case is falling apart. But I mean, you're going to hear testimony from people who are going to give in what sounds like incriminating evidence, and you're going to have other witnesses who don't. I mean, you're going to have two experts for the prosecution say there's no Google search at 227, and that. And there's going to be an expert for the defense who says, yeah, there was. And then he's going to say, there's one deletion out of over 4,500 searches. And then he's going to say it's that. And that's going to sound great. But what's the point of doing this? Let the lawyers try the case, have faith. Burden of proof is on the prosecution. All they need to do is establish reasonable doubt. And one of the first things I told you over a year ago, once we learned about the case and moved on from, wacky Wendy talk, was it really struck me as pretty quickly there's reasonable doubt just dripping all over the place.
Everywhere.
It's everywhere. Doesn't mean they have to establish her innocence. It doesn't mean they have to do anything other than poke holes and establish reasonable doubt. And I can't fathom a way, based on what's out there in the public right now, that they're going to get 12 people who are going to say that there is literally no reasonable doubt. I can't think of any scenario in my mind in which she didn't do this that is me being reasonable, as opposed to I hate her, as opposed to I just wanted to go down because I hate her. Okay? I just don't see how that's ever going to happen.
I don't either. I don't see how she can get convicted. I see a hung jury, or most likely, again, unfortunately, or not guilty. I mean, look,
it's too early to predict what's going to happen. I think
it is. We got a long trial, right?
The problem here, again, I don't want to overplay this, but since jury selection is kind of the topic of the day, to not allow the lawyers to just probe their issues, start the process of, seeing how they react to issues that'll come up in the case, running from one juror to another, playing off answers, seeing how they interact. One could argue that those are the kinds of things that even lead to hung juries. You just don't know what you're picking. I mean, and it applies to both sides in all fairness. It's not but I feel that you have really charismatic lawyers for the defense who I think play better in front of a jury, just in terms of personality. They just seem to emote sincerity in what they believe, really good communicators. And I think it's terrible to deprive that right out of from the jump, the chance
right out of the gate. Yeah. Right out of the gate.
Let the jury know we're the good guys. And, you can let me guide you by the hand and we're going to get there. And they don't really get the chance to do that, which I think is regrettable. And it also means that the first time the jury is even going to really understand who the defense attorneys are is after Brennan has already given an opening statement, which is another huge disadvantage. I mean, they just don't even know who the defense lawyers are until somebody gets up and gives an opening statement.
It's a disadvantage. That's a long way in.
Yeah.
This question, I'm going to bring it up because they said they've been asking the whole time, and I believe it because I did see it earlier. And it's hard to keep up with the questions. Sometimes you even hit on the wrong ones. They said we would love to know Mark's opinion on the stipulations asked for by Hank.
100,000% unequivocally. In case you didn't understand how certain I am, no. Okay.
What were the stipulations? Can you go over that again? Because I don't remember.
Other than the one about possibly to keep the lawyers on, I wouldn't stipulate the shit with this guy for the simple reason I don't know what I'm stipulating to, and I'm afraid of what's happening. I have trust issues. Okay. I have concerns about your representations. And I would say I'll sit here for 4 months to try this case, call every damn witness you need to call to prove what you need to call. But I'm not agreeing to anything with you at all because I don't trust you. And based on what you've seen in the courtroom, I'm not sure why they would. So I think you would have to have a really good reason to agree to do that. Now, normally I would say yes, if there's something that's not in dispute, and I haven't seen all the stipulations. If there are issues that don't matter and are not in dispute, they're ministerial, fine. But anything involving anything remotely important, I wouldn't give that guy an inch because he's going to try to take a foot.
I love it. It's so true. He's not trustworthy. No question at all. I wouldn't trust him at all.
No, and it's terrible when litigation becomes like this. I mean, believe it or not, lawyers
that way. Yeah.
can try really difficult cases that are really contentious between, defendant facing life in prison, a horrible crime, but you can try cases in a very respectful, even friendly manner, as long as everybody knows there are boundaries and you're not going to favor him because he's a nice guy. You're going to work with the client first. But, it's a shame when a case of this magnitude devolves into what this is. But I just don't know why they would trust anything that he says unless there is uncorroborated proof of it. I mean, they had to sit there and listen to this guy accuse David Yannetti of making out-of-court statements on court TV when it was freaking court. Okay? And let's be honest. No one at the prosecution table jumped in and said, you're wrong. Okay? They had to listen to all that nonsense about the feds giving us these materials that the defense didn't, and they were wrong. No one at the prosecution table got up and said, actually, you're wrong. He only corrected himself when judge came out and looked a little upset. Okay? But this has gone on again and again and again. And they're fighting for their client's life. And if it takes 4 months instead of 2 months, because that's what it is, then you roll up your sleeves and say, we'll sit here to September if that's what it takes. But we're not giving you an inch, no quarter, prove your case, or go home.
I love it.
Well, this is a joke. This is exactly the point. To suggest with a straight face that you should stipulate to a video as accurate, the gall to even ask that is absurd. Never.
Nope. Yeah, they're saying metadata is a stipulation. Oh, this is great. But
that's another form of gaslighting too, to make it look like I'm trying to move this along. I'm trying in good faith. And then when the judge is like, well, how about we do this to move it along? And the defense says, well, we don't feel comfortable doing that. Who looks like the bad guy for delaying things? You know what I'm saying? Like it becomes another.
Totally. He plays games. He's such a game player on this stuff. I think he's going to turn off the jury in the end. I do. I mean, don't you think he will? Do you think How do you think the jury's going to react to him?
I mean, it really depends. Look, he's skilled. Let's be honest. I mean, fair is fair. He knows what he's doing in terms of public speaking and whatnot. The level of aggression and tone and snippiness will not play well, particularly because he's the prosecutor, okay? And again, their role is supposed to be, look, I'm wearing the white hat. I'm going to lay out the evidence, and I'd like you to come with me. It is what it is. I'm just doing my job here. But there is that, level of snippiness and pissiness you've seen with certain witnesses. No jury, so we'll see if that was an act for out of the jury or not. They don't want to see prosecutors who are over aggressive. That freaks people out. Normally, people would expect defense attorneys to be like that. So we'll have to wait and see. But if it's the same demeanor you've seen so far, I would be very concerned because the defense attorneys project as much more likable, earnest people in what they're doing. Now, that doesn't mean that he can't do it. And maybe it is an act. And in all fairness, I've never seen him in front of a jury. So who knows? But I would be concerned if, I'm rooting for the prosecution, that the prosecutor comes off in such a hyper aggressive posture and tone. We'll have to see. But, he's not going to win a battle of, flash in front of the jury with Alan Jackson. Like, that's not going to happen. So we'll just have to see. He's not going to be Lally again. He's not going to be, give off that appearance of just being defeated and downtrodden and, tired. And I mean, we used to say like the, guy making the donuts, that kind of thing.
Make the donuts.
I mean,
that one.
So, but on the other hand, in hindsight, Lally, if you do a reevaluation, appears with the benefit of hindsight to maybe have been a little more effective and a little more charming in that downtrodden way than you might have thought now that you've seen going from him.
Yeah, really.
Hyper aggressive, guns a-blazing. But again, in all fairness, you won't know until there is a jury, because when there's no jury, lawyers do tend to act differently. That is true. We've all done that. You take more liberties when there's no jury.
Yeah. You act different. It's like being in front of your mama, right? Or your boss or somebody that you're trying to impress, right? I mean, a little bit when you're in front of the jury.
On the other hand, what's interesting is this judge doesn't entertain theatrics much when the lawyers get fired up, for good reason, by the way, a lot of the time, and just says, there's no jury here. Would you not do this? So it's really a hard read in this courtroom, because the judge is very involved in things. She's just more active and come up here and why are we doing this? And because she has all these constant sidebars and interruptions, that's just her style. And it's her courtroom. She can do whatever she wants. But the trial has very little flow, or at least the first one did. And, that's probably going to happen again. So that can also impact skilled advocates in front of a jury when it's always getting broken up. You don't get the chance, to get your mojo flowing, so to speak, and get into that cadence of here we go, or as we like to say, there are times you say like, I'm dancing today. Like, you just know you're on it, there isn't much chance to do that as much in that courtroom, just because it's very, it does tend to get broken up. It's choppy. If you look at the transcripts or watch the videos, it's very choppy. There's very little volleying, if you will, without interruptions or sidebars or something.
True. There's been people that have been putting videos together of the last trial where they take out the sidebars, they take out all the interruptions, and you turn like a 6-hour day into like an hour. Like it's just so compact because of how many breaks and interruptions and just it's unbelievable.
Yeah, and also, if I recall correctly, they weren't really working 5 days a week. They weren't working till 5 o'clock, which adds time and drags on. And I think if you ask the lawyers, maybe 4 days a week, a day off in the week in a trial like this is not a terrible thing, in all fairness. But if you could lop off a week or two by simply working 9 to 5 with breaks, of course, rather than till 2 today and we're off tomorrow and then 1 the next day, I think more consistency in getting through it and more predictability in schedule would help everyone.
Excellent. I want to thank you so much for being here. Do you have any upcoming scheduled shows or appearances on other networks or channels coming up?
I do. Let me just check. I'm gonna blow this.
That's all right. People like to know where you're gonna be next.
I believe Sunday in the morning, actually. Right? Sunday, 11 o'clock, I think. Did I not put it in my calendar? I thought I did.
Oh, I know that's Calling All Beings, right? With Brother Counsel. Is that the one?
Yeah. Yeah.
I saw that one advertised. That looks good.
Yeah. Is that Sunday at 11? Because I guess I did not put it in.
I saw it was a daytime. I'm not sure if it's Saturday or Sunday, but next weekend. People know where to look. Calling All Beings, daytime weekend show.
I didn't write it down. I thought I did. I need to put that. I'm pretty sure
we'll make sure we get the word out.
I'm a trained investigator. I'll find out. It's okay. I can handle it. But
I'm looking forward to that. Have you done a show with Brother Counsel yet?
I think a long time ago, back when they used to invite me on the Survivor, what's it called?
Surviving the Survivor.
Yeah, I think there was an overlap of, a segment or something on that. I think it was that one.
I like how Sweet Pea says, please ask him my question, like I'm going to be able to find. Instead of just writing the question again, Sweet Pea.
See, this is where you jump in and say, send a super chat. No, I'm kidding.
Yeah, send a super chat. Don't send any super. The people, I actually turned it off because I turned it back on because I thought we were leaving. Now people are starting to send questions. So I'm going to let Mark go. And if you want a question answered, ask the question. Don't ask me to look through 10,000 questions. Thank you so much, Attorney Mark Bederow, for being here. We'll look for you on Sunday. Yeah, they're saying it's Sunday, 11 a.m. with Brother Counsel. See, Ruth knows. You were right. I think you got it right. You had it right.
I have a memory. I don't know why I didn't write it down. I was pretty sure I did, but it's okay.
Oh, no worries. We got it in. I want to thank you so much, and hopefully we'll have you back on soon too. I don't know, as soon as the real stuff starts happening. I can't wait to we have court things to talk about.
That'll be much more interesting, obviously. But
yeah,
jury selection should be interesting, but in this case, it's very regrettable that it's just kind of an afterthought. That's really regrettable.
That's right. Thank you so much, everyone. Love this tonight. We'll see you soon. Go Celtics. Thank you so much, Attorney Bederow.
Okay, we'll talk. Take care.
Thank you, Mark.
All right, bye.
Bye now. That was Mark Bederow. I want to thank him so much for coming in tonight. That was a great show. I did turn on the super chats right at the end, not for questions. We're not taking questions from Mark Bederow via super chats anymore. We're trying to wean people off of that. That's not the way we're doing it. But if you want to make a super chat now, you can definitely do so. If you want to thank us for the show tonight, thank the Young Jerks, thank myself. That's a good way to do it. I want to thank Julie Davis, who gifted 5 Young Jerks memberships. Thank you so much, Julie. Thank you, Donna, tonight. Thank you, Jersey. Thank you, Gina. And thank you, Pearl Cat, too. I don't know. I didn't see it. I know you want to ask Mark that, but we weren't doing that via super chat tonight. Just turned it on right at the end, because if anyone wants to give a donation, you can do so right now. But we're not doing the questions via that way. And I want to thank everyone who's been here tonight. I want to thank our moderators, MJ. She's going through some stuff. I don't know if she was in the chat too much today, but we love MJ. I want to thank MJ for always holding it down for the young jerks and being the best moderator around. I also want to thank Stephanie and Sarah and Shakanhara, Jeno, and Scott McGinnis, who are also in the chat tonight. I love our moderators. Thank you so much to them for always being here. Oh, thank you so much. Hey, it's me. I love that. Thank you so much. Thank you, Denise, too. Thank you, Mike and Mark. Thank you so much, Denise, Noel. And thank you, Michelle L. Thanks, Mike. Get Michael Easter on your show. It's so funny, Michelle, as you say that. As soon as that news broke, I looked him up on LinkedIn and I looked up his website, and that message had already went out. Like that message was out as soon as that news broke. I already sent him a message. I'm not sure. I still don't think he'll probably come on the show, but I did send him a message. I want to have him on the show if he can do it. I have a feeling he's probably going to wait till the trial's over. Thank you, PTSD Healer. Thanks, Crawdad. Great show. Thank you so much. Tomorrow night at 6 p.m., I'm going to have Michael Carlin on. He's the researcher that's done a lot of research. He's written books. He's been in movies. He's been in a producer, researcher about the Biggie and Tupac murder investigations. I'm looking forward to that. I've been watching Michael Carlin for decades. I can't wait to have him on the show tomorrow night. We tried it the other night. It didn't work out. We're going to try take 2 tomorrow night, Tuesday night, 6 p.m. Please definitely check that out. On Friday night, I have AV to the 7th Power. She's got a YouTube channel, an attorney. I'm looking forward to having her on for the first time on Friday night. That's going to be a big show, a fun show. Check it out on Friday night. I want to thank attorney Mark Bederow. I also want to thank Mazza Media, our boy. He couldn't be here. I saw a lot of comments. People still have concerns about Mazza. Mazza's doing fine. He needs a break right now. There's some personal stuff going on. Like I said before, I think if you really want to help Mazza, just give him love, give him support. Don't ask too many questions. Let it be a personal thing. He needs his privacy. And he is on Twitter. You can still talk to him. He's still around. He's not disappearing. He's still free Karen Reed. He was watching tonight. He supports us. He helped me book my last show, the big fundraiser. Those were all pretty much guests that Mazza booked for the show last fundraiser we did for Karen Reed. Thanks, Crawdad. Great show. I think I read this one earlier, but what I like about it is a Crawdad. I wonder did you go to Bridgewater with me? They used to call me that at Bridgewater. Thank you, Innocent and Defiant. She also sent $9.99. Thanks, Mike. Thank you so much, Innocent and Defiant, tonight. I want to make sure I got all of our new YouTube followers here. Thank you, Gina. Thank you, Jersey Jen. Thank you, Donna. I think I thanked Julie already. Yes, I did. I want to thank everyone who's been watching tonight, supporting all the questions. You guys had some great questions tonight. It was phenomenal. Always good to have Bederow on the show. And again, like I said, we'll be live tomorrow night. I'll be live 6 p.m. with Michael Carlin. And you might have seen him. If you haven't seen the movie, you should check it out. Tupac Assassination, Battle for Compton. Great documentary movie he's in with R.J. Bond and some of Tupac's bodyguards who are no longer. Some of them have passed away. That's a great movie if you want to just check it out before the interview tomorrow night. He's also got a book called Chaos Merchants. That's phenomenal. He's also been in the A&E series with Benjamin Krupp about Tupac and Biggie. So check him out. It's going to be exciting tomorrow night, 6 p.m. Young Jerks. And again, on Friday night, going to be back with a big show too. And I'm obviously I'm trying to keep some space this week in the middle for maybe some nights off, but also I want to keep up with what's going on in Canton because there's a big election coming up a week from tomorrow night. So a week from Tuesday is the Canton Select Board election. It's already started. Early voting's already started, but we'll see some results hopefully on Tuesday night. But in the meantime, the Canton police audit apparently is going to be coming out this week as well. So I'll be covering that as well. Please like and subscribe if you haven't. If this is your first time, or maybe you've been here before and you haven't liked and subscribed, please make sure you subscribe and come back. I want to thank Melanie Little tonight. and all the cupcakes who showed up tonight. I love the raid from Melanie Little. It's very special when that happens here. I love Melanie Little. I'm not sure if that here, they're having a public meeting about the audit on Saturday. I'm not sure if it's going to be broadcast live. I have a feeling that either way, Canton Cable will record it and we'll get to see it eventually. Whether it's live or not, I don't know. We'll try to find out this week. How can you win the free memberships? You just have to kind of be in the YouTube chat when people gift them away, and YouTube selects it randomly. So it's really a YouTube thing. And this is what I love from Innocent and Defiant. She says, sending love, Mazza. I love it. Thank you, Scott McGinnis. I think I'm going to close tonight by playing some Jen McCabe. We got some Jen McCabe from a while ago, from when she was testifying. Our friend who was on the show the other night, attorney Nan Gallagher, Laferio, who was in the chat tonight, she said, please don't quote me. I'm sorry I quoted you. I hope I didn't misquote you. You did a great job on the show the other night. You always do, Laferio. Attorney Nan Gallagher, she brought up the fact that was who she would love to cross-examine the most. So I thought it was a good time to bring up some Jen McCabe video tonight. At 9 p.m., I'm pretty sure that's the time, LTL Media is going live. We're going to redirect you there then. But until then, I'm just going to play a little video from Jen McCabe just to get us in the mood. Because, this is what we got to look forward to. We get to look forward to seeing these folks back on the stand. There she is, Laferio. She's watching. She said, love. Thank you so much, Laferio. Nan Gallagher. She's phenomenal. She is so good on the show. Her and Bederow both are just phenomenal. We're so lucky to have them. So let's do that. I'm going to close with that tonight. And again, I want to thank attorney Mark Bederow. I want to thank our moderators. I want to thank everyone who sent questions tonight. I want to thank Mazza Media, who couldn't be here as well tonight. Thank you so much. We're going to have a great trial, hopefully, coming up. And let's watch a little of Jen McCabe tonight. Check this out. I can get this up. Hold on one second. Hold on. I want to make sure I get it in at the right time here. There we go. And this is trial 1.0. Jen McCabe. Let's just watch some of this cross-examination that she went through last time.
Aren't you? Over and over and over.
I am telling them what is going on. I wouldn't say it. Well, let's count them. Was there 4 of them? You're saying over and over and over and over. It's a bit extreme.
I see. So you take issue with the way that I phrase over and over and over.
Well, it's misleading, I believe.
I see. Okay. Well, let me see if I can try this in a non-misleading way, Mr. McCabe.
Okay.
So at least one of us. I'll withdraw. You consistently reported back to the group how Kerry Roberts was doing with the police, didn't you?
I would update them after Kerry saw and spoke to the police. Again, we were all trying to figure out what had happened to John.
There's yet another text from Brian's wife, Nicole, on January 29th, and this is on page 2226. And she says, quote, we'll get more info tomorrow. Don't want to text about it, end quote. And then you texted, right, correct?
Correct.
What's that about?
Objection.
I'll allow it. We decided that we would talk on the phone. My children look on my phone. Her children look on her phone. We were working with the police. I was sharing information and everything that had happened. we didn't want it to leave our little circle because we were trying to figure out what happened, and we're not going to go running around letting people see, oh my gosh, they think this might have happened or that might have happened. It was nothing more than let's not text about it.
So you wanted to keep it, in your words, in your little circle, correct?
Correct. I didn't want it all out there what we had thought had happened. I was going to let the police do their job.
So by definition, the info that Nicole Albert was talking about, that needed to be kept very tight, very secret, correct?
We needed the police to do their job. So we weren't going.
Texts, and Nicole wanted her texts, and the group wanted their texts to be kept secret and private. Isn't that right?
Not secret and private. We just weren't going to communicate certain things over text.
Did you give, or did anybody give you any private information the next day on January 30th?
Didn't even give me private information.
So let me put it in context. That text from Nicole Albert, we'll get more info tomorrow. I don't want to text about it. That was on the 29th, right?
Okay.
So, did you get additional info on the 30th, the next day?
I have no idea.
Did anything significant happen on January 30th in connection with this case? Any meetings, any get-togethers, anything that you can think of?
I went to the O'Keefe's house.
Other than that, anything else?
On the way home, Kerry Roberts' daughter is good friends with Michael Lank. So we dropped her off at Michael Lank's house, and Mike's wife came out of the house. Him and Kerry are friends, and she, jumped in the car and was consoling Kerry and asks how the O'Keefes were doing. And, we talked to her.
So you pulled up to Michael Lank's house on the 30th. That's never been reported, has it?
I guess I never thought much of it.
Never thought about reporting the fact that one of the first responding officers on the case, working for Canton PD, which is considered off the case, you had a meeting with that was unreported the next day?
I didn't meet with Michael Lank.
I see. So you pulled up in the car. Tell me about that again. You pulled up in the car, and what happened?
And Lex, her daughter, went into the house.
Okay. And then you just drove away?
No. Michael's wife came out of the house.
Okay. And y'all had a conversation about what?
She got in the car, and her and Kerry are friends, and she was checking on Kerry and, just saying, oh my God, this is so crazy, just checking in on the O'Keefes.
How long did that take?
Well, Kerry's a talker, so could have been an hour.
Could have been an hour standing outside?
Sitting in the car.
Sitting in the car on February 30th. Never came in the house?
Not February 30th.
I said February 30th, January 30th. Never went in the house?
I might have ran in to go to the bathroom.
It's the back end of a blizzard. It's freezing cold outside.
Mhm.
Sitting in the car for an hour?
The car was running, Kerry, and they were talking. It's her friend.
Did you have any conversation before your testimony today with anybody about you going to Michael Lank's house on January 30th? Anybody?
Yes,
Tell me about that. Who was it and when?
it was a couple of weeks ago at the DA's office.
The DA's office had an interview with you, correct?
Not an interview, they just explained this process.
I mean, a conversation? How about that?
Yes.
You met with folks at the DA's office. Who'd you meet with?
Mr. Lally, Ms. McLaughlin, Steve Nelson, Trooper Brian Tully, I believe, and another woman, I can't remember her name, unfortunately.
Someone from the DA's office?
Yes.
Beelan?
No.
Lynn Beelan?
No, she's here today. She works with Steve Nelson.
But an employee of the DA's office?
Yes.
That sounds like a pretty big meeting.
I wouldn't call it a big meeting. There was, what, 5 of them?
How long did you, 5 of them and then you? Right?
My daughter Allie came with me also.
The meeting's getting bigger. Anybody else?
No, we both went.
Was Allie in the room when you were, I'm going to say interviewed, but you take issue with every word I use. When you were talked to by the DA?
Allie and I were both in the room when they went over everything, you know, how this all works, because this is all brand new to us. And then they asked me to leave the room.
You were about to say, and I lost the end of that sentence, when they received what?
I didn't mean the word received.
Did you receive anything?
No, I looked at my grand jury notes.
Now, at this meeting, was anybody taking notes?
No.
You have a bunch of lawyers and DAs, and nobody has a notepad in front of them, like notes?
I believe Mr. Lally had a number of folders on the table.
Taking notes?
I do not believe anyone was taking notes. It was a casual meeting to explain this process.
Was that meeting recorded in any way that you're aware of?
No.
How long did the meeting last?
Allie and I were probably in the room, I don't know, approximately 20 minutes. Then I left and they spoke with her. And then I went back in and they spoke with me.
How long did they speak with you?
Honestly, maybe half hour.
And during that half hour to an hour, did they go over with you what they expected your testimony to be?
They never spoke about what they expected my testimony to be. They just showed me some pictures that might be shown. I listened to the 911.
What pictures?
Just of the house and how I'd be asked to, show, okay, we're going to put a picture of the house and you'll have a laser.
Okay, when we started this conversation, it was because you said, in answer to my question, was anything ever brought up to you about this meeting at Lank's house?
Mm-hmm.
You said yes.
Mm-hmm.
So obviously they did talk to you about your testimony. It wasn't just about the process, correct?
I asked what discovery had been turned in regard to me.
So you wanted to prepare to make sure that you knew what you might be asked on cross-examination, correct?
I wanted to know what was coming, yes.
And you knew that one of the things was coming after this meeting. Well, let me ask it a different way. During this meeting, did Mr. Lally tell you one of the things that's going to be coming is you had an off-the-books meeting at Lank's house for 45 minutes? Did he tell you that?
No, that's not how I was told.
Did he tell you that the defense had uncovered a report that established that you were actually at Michael Lank's house for 45 minutes that had never been reported to the defense or the prosecution before the phone extraction had been done? Did he tell you that?
I was asked, oh, were you at Michael Lank's on the 30th?
So you've had a lot of time to come up with a story about why you were at Michael Lank's, correct?
Objection.
I'll allow it. I didn't need time to make up a story because I have the truth of why we went.
And the truth, according to you, is you pulled up at Michael Lank's house. The first responding officer and friends of the Albans had a meeting with him the next day that was never reported to anybody for any purpose.
I
Just met with his wife out in the car while the car was running for 45 minutes to an hour. That's your story.
It's not a story, it's the truth. Carrie dropped her daughter off. The wife came out. Carrie is a talker. They started talking. A tragedy had happened the day before.
It is interesting, would you not agree, that the day before you had this off-the-books meeting at Michael Lank's house, Nicole Albert says, we'll get more info tomorrow, meaning the very day you show up at Lank's house.
Again, I never spoke with Mike Lank at his house. It was not an off the books meeting. It was Kerry dropping her daughter at one of her good friends' house, whose husband happens to be a Canton cop. That is what it is. That is the truth.
A lot of coincidences.
Objection.
Sustained.
Yeah, just call me out.
Yes.
That's, by the way, what did Mr. Lally show you in respect of this issue about this meeting at Michael Lank's house?
He showed me nothing.
He just told you about it.
Brian Tully told me.
Okay, what did Mr. Tully tell you? Trooper Tully, what exactly did he tell you at this meeting about this Michael Lank issue?
He said, did you go to Michael Lank's on January 30th? And at first I said, no, I've never been to his house. And then I thought about it and I said, oh my gosh, yes, I did go there. And that was the extent of the conversation.
You said, yeah, I did go there, and he didn't ask a follow-up, like, what the heck were you doing at Michael Lank's house the day after this issue?
Objection.
This incident?
I'll allow it.
He didn't ask a follow-up like that?
I do not believe he did.
So Trooper Tully had you come down for an interview. He confronted you with a fact that had never been disclosed before, to wit, you showed up at Michael Lank's house, and when you said, yeah, oh yeah, hang on, I think your words were, oh my gosh, yeah, I think I did go there. And he didn't ask a follow-up question?
He was there.
Yes or no?
You're spinning all of this.
Ma'am, I do a lot of things.
Yeah.
I don't spin. There's a judge here to make sure that I don't spin. I'm asking you a question. It's very direct.
I do not believe he asked me a follow-up question.
So that was the end of that conversation about Michael Lank, correct?
Correct.
Mr. Lally didn't have any follow-up questions.
I don't believe Mr. Lally was in the room.
Who else? I thought you said Mr. Lally, Ms. McLaughlin. I thought
They
you
were. They might not have been in the room at that time.
I see. So Mr. Lally just happened to, what, just saunter out?
It was a different time.
So Mr. Lally was in and out of the conversation?
Mr. Lally was not there when this conversation happened.
Well, why is that?
Because I met with Brian Tully and he was not there.
Is Brian Tully taking notes?
No,
He's a state trooper interviewing a witness, and
He was-
Objection.
Sustained.
The same report that has you at Michael Lank's house
Mhm.
also has you picking up Nicole Albert going by 34 Fairview just before you went to Michael Lank's house. You aware of that?
we did not pick up Nicole Albert.
So you went by 34 Fairview, then diverted, and right after you went by 34 Fairview, went directly over to Michael Lank's house. What was the reason that you stopped by 34 Fairview?
We didn't stop by. Maybe Carrie slowed down, but we did not stop by 34.
So you drove by, did a drive-by 34 Fairview. Giggles? What?
No, that's how we get to Michael Lank's house.
If the report shows that you actually stopped at 34 Fairview and then went to Michael Lank's house, would we have another oh my gosh moment?
Nope, no oh my gosh moment. We did not pick up Nicole Albert.
Did anybody else go with you over to Michael Lank's house?
No, it was Carrie, myself, and her daughter.
Your Honor, maybe approach briefly.
Okay. Jurors, we're going to try and go right up to 1 o'clock, okay?
Ms. McCabe, we've talked in some detail about your calls with John O'Keefe on the morning of January 29th. Do you recall that
Yes.
conversation? I want to focus your attention on or about, or at or about 12:14 a.m., moving up to about 12:50 a.m. You have that time in mind?
Yes,
You've seen the Celebrite extraction from John O'Keefe's phone, which Mr. Lally showed you the other day, correct?
correct.
And you went through the series of phone calls that were made and that appear on his extraction report, correct?
Correct.
I just want to run through those time-wise very quickly, just to orient you, if I can, and then I'll ask you some specific questions about it. There was a call at 12:14 a.m., correct?
Correct.
That was a call that you indicated was answered. You had a conversation with Mr. O'Keefe.
Correct.
There was a call at 12:18 and 47 seconds. That call also was answered by you. John O'Keefe made that phone call, correct?
Correct.
Then there's the 12:29 and 44 second call that you indicated was not answered.
Correct.
And that was a call to you, from you to him.
Correct.
There was a 12:41 call from you to John O'Keefe, correct? That was,
Correct.
there was a 12:41 and 54 second call from you to him. Is that right?
Correct.
There was a 12:43 and 19 second call from you to him.
Correct.
12:46 a.m. and 16 seconds from you to him.
Correct.
12:47 and 52 seconds from you to him.
Correct.
And 12:50 and 37 seconds from you to him, correct?
Correct.
You saw in his extraction report that all of those calls after 12:18 were missed calls, correct?
In his report that you showed me?
Correct. In other words, the only two calls that were answered were the 12:14 and 12:18. Everything else was a missed call.
I believe so. I would have to refer to it again because I've seen so many reports.
And Ms. McCabe, according to the extraction reports that you've seen this morning, comparing yours to his, every single one of those calls was deleted off your phone, correct? According to the reports.
According to that report, yes.
Let me ask you another question. Have you ever misplaced your phone?
Yes.
Just in life, everybody does it, right?
Yes.
What's one of the first things you do if you're with your daughter or your husband or a friend and you're in your house and you misplace your phone? What do you do?
Oh, I'll ask them to call my phone.
Even over and over and over, right?
Correct.
Could be as many as 5, 6, 7 times.
Usually I hear it the first or second time.
You're looking for a buzz or a ring, isn't that right?
Correct.
And you might do that if you're searching for a missing phone, correct?
Correct.
With regard to the call that were deleted from your phone, you were asked about this under oath at another proceeding, weren't you?
Correct.
And you claimed at another proceeding that you had an explanation for all these missed calls, starting at 12:29, 12:41, 12:41, 12:43, 12:46, 12:47, 12:50.
Mhm.
You have an explanation for that, right?
Can I see the report?
I'm asking you about your prior testimony.
And I'm
Asked
asking,
about these calls.
yes, I'm asking, can I see it, please?
I'm asking you a different question. At this other proceeding, which
Mhm.
you were under oath,
Yes.
you explained that these calls were what? These missed calls, incessant missed calls. What were they? You used a word. Matter of fact, 2 words.
I believe I used the word butt dials.
You claimed that every one of these calls was a butt dial. Is that right?
Yes.
So according to you, you literally butt dialed John O'Keefe's phone 6 times in the span of 19 minutes. Is that right?
I don't remember making any of those calls. So my assumption is I put my phone in my back pocket and that was it.
When you dial someone by mistake, you hit a button, set your phone down, the phone has to be open, you'll agree with that, right?
Correct.
Can't be locked. It takes several iterations of movement to get a phone open, Face ID or password, right?
Correct.
So when you hit the button by mistake, walk away, that's a butt dial. People call butt dials. What happens with the call?
I assume it goes to voicemail.
Good assumption, because that's exactly what it does, isn't it? You've had a phone for a lot of years, right?
Yes,
It rings and rings and rings until it goes to voicemail.
correct.
So in order to hang up that butt dial, you have to interact with that phone yet again, don't you?
Yes.
So if you had 6 butt dials, 7, I think it's 7 butt dials, you'd not only have to interact with the phone once to butt dial John, you'd then have to interact with it every single time to turn off that phone ringer so it doesn't go to voicemail, wouldn't you?
I suppose.
Which makes 14 interfaces with that phone over the course of 19 minutes. Is that right?
I mean, I guess I don't have it all right in front of me, but there were also text messages I was sending. So again, maybe I said, oh, shoot, I called them and then I turned it off.
But your claim is you don't remember those incessant butt dials and those incessant hangups at all, correct?
I honestly don't.
So you would have had to forget that you interacted with, by the way, you'll agree that the phone extraction shows that John O'Keefe got no voicemails from you, right?
I didn't look, but
So that means you would have had to interact with that phone 14 times over the course of 19 minutes at the exact time frame that the Commonwealth suggests John O'Keefe lost his life.
Objection.
Sustained. You can ask that differently, and this will be your last question for today, please.
Yes, Your Honor. The period between 1229 and 1250, which is the exact period that you were, quote, butt dialing John multiple times. That's also the exact period that John O'Keefe was rendered incapacitated. Isn't that right?
Objection.
That's sustained. We'll start up again tomorrow, okay?
Thank you.
All right, folks, so I'm going to, once the stadium walk.